And a good Sunday evening, everybody. Welcome to Bethea'S Byte Reloaded. Oh my gosh, already I've got a little something to chat. Nana's Dragonfly, good evening. How are you? How you doing? Welcome to the drama-free true crime destination, and we got a lot to get through as the title to tonight's edition is implied. More cases, more updates, and surprisingly, more Diddy. So come on in, get comfortable. Thank everybody for joining me this evening. I'm encouraging you to like, share, subscribe, drop me a comment here in the chat or in the community section, and this is a free way to support Bethea'S Byte Reloaded. I would love to have that support. But if you want to do so by do a monetary support, that would be great too. You can hit me up on PayPal, paypal.me/EKB316, Venmo $EKB316, or Venmo/U/EB the Last Outlaw. Like my good friend Brittany J would say with hers, nothing's obligated, but it's always appreciated. Alright. The live panel is wide open. I'd love to have you. I'd love to have you there. I have the link pinned in the chat, so all you gotta do is drop it down, click on it, come on in. I'm more than happy to have you. Also, I left a little poll on the in the chat too. I do a little something now at the end of every edition. I'm calling Last Rites. It's reserved for those who have been convicted and sentenced to life behind bars without the possibility of parole, or even worse, the death penalty. So my question is this: should I continue with it? The polls in the chat. Let me know what you think. And we all know the rules. We all know that everything we say here is either speculation, deduction, theory, opinion, nothing considered evidence unless it's otherwise stated. We already know the rules. I don't need to go through that. We already know how to get rid of somebody if you don't like what they're doing or what they're saying here. In fact, I'm giving you this trigger warning, but I want to give you a little surprise too. The next time I need to do a trigger warning for a story, it'll be scrolling at the bottom of the screen here, as well as the copyright disclaimer. See, yes, I come extraordinarily prepared. And so right now we got our title back, and let's see, where was I at? At everything you get to hear. All the stories you're going to be hearing from this evening, as always, is coming from the original drama, the original true crime obsession, my good friends at Court TV, your front row seat to justice. Alright. Now that we got that out the way, it's been a couple of weeks since I've done a missing persons story, so I'm gonna go ahead and break that streak right now. Take a look at the left side of your screen. That's mom and daughter. Mom's on the right, daughter's on the left. This is Liliana and Daniela Moreno. Here's the information as I have it. The FBI's Miami Field Office's South Florida Violent Crime and Fugitive Task Force is seeking the public's assistance in locating Liliana Moreno and her daughter Daniela Moreno, who have been missing from Doral, Florida since May 30th of 2016. They were allegedly last seen at or near the Home Depot located at 13895 Okeechobee Road in Hialeah, Florida. They have not been seen or heard from since that day. Liliana is described as a white or Hispanic female born December 24th, 1973. She has brown hair, brown eyes. Daniela is described as a white or Hispanic female born October 4th of 2007. She too has brown hair and brown eyes. This investigation is being jointly conducted by the Miami-Dade Police Department, the City of Doral Police Department, and the FBI. Now this is where we need to pay close attention. The FBI is offering a reward of up to $25,000 for information leading to the whereabouts of Liliana and Daniela Moreno. So we need your help in this. If you or anyone you know have any idea where Liliana and Daniela Moreno are, please do not hesitate. You're asked to call 911 immediately. You're asked to call the FBI's 24-hour tip line at 1-800-CALL-FBI. 1-800-223-5324. Excuse me, 225-5324. You can also submit your tip anonymously at tips.fbi.gov. tips.fbi.gov. But whatever you do, if you see something, please say something. That way we can do something. We want to be able to find and bring home safely both mother and daughter, Liliana and Daniela Moreno. All right? Okay. Now that we got that part taken care of, let's get down to the business that was this past week. We're going to kick things off with teen murderer Gregg filing appeal citing new evidence. Yep. The attorney for a teenage girl sentenced to life in prison for murdering her mother and trying to kill her stepfather has filed an appeal citing new evidence and a series of errors at her trial. 15-year-old Gregg was sentenced by a jury, which took less than an hour to decide that she should spend the rest of her life behind bars after finding her guilty of murder, attempted murder, and tampering with physical evidence. In a motion filed on September 26, Carly's attorney has asked for a new trial or, in the alternative, for the jury's verdict and sentence to be set aside entirely. At her trial, Carly's attorneys conceded that she had killed her mother and shot her stepfather, but argued that she was legally insane at the time of the crime and had been suffering from an undiagnosed mental illness. Psychiatrist Andrew Clark, hired by Carly's defense, testified that she had an unspecified schizophrenic disorder. In her motion, defense attorney Bridget Todd said new evidence came to light after the trial, adding further weight to that diagnosis. Todd said that a reporter for WLBT contacted the defense team after Carly's biological father, Kevin Gregg, talked to the television station for an interview. In that interview, Kevin told the reporter that his daughter had suffered from auditory hallucinations as a child and was put into equine therapy as a result. The motion notes, however, Kevin Gregg refused to cooperate in Carly's defense, refused to talk to the state, refused to talk to mental health professionals evaluating Carly, and refused to come to any pretrial hearings or a single day of Carly's criminal trial. So wait a minute. All that comes up and her biological father doesn't even bother to jump in on his daughter's behalf. But he wants to he wants to add his 2 cents that that there's something mentally wrong with Carly. Number one. I mean, number one. Number two, if I can go back to the article, she went into equine therapy, meaning that her therapy was going be around horses. I don't know, riding horses, taking care of horses, grooming them or whatever. Still, that kind of therapy. But he refused to cooperate in Carly's defense. He refused to talk to the state. He refused to talk to mental health professionals evaluating Carly, and refused to come to any pre-trial hearings or a single day of Carly's criminal trial. Okay, somebody tell me where does all that make any kind of sense? Because it doesn't to me. Maybe, just maybe, Court TV's Julie Grant can can shed a little light on this. Hang on, guys. Let me get everything set here. Okay, there's the copyright.
Now to our top story this morning. Convicted killer Carly Gregg could get a new trial as her defense team is filing a motion for a brand new trial for her. This is coming less than 2 weeks since the judge sentenced her to life in prison without the possibility of parole for murdering her mother and trying to murder her stepfather. Now, the defense is claiming in their motion that new evidence has been discovered that was unavailable during the trial, including an unaired portion of an interview that Carly's biological father, Kevin Gregg, did with TV station WLBT. He says that Carly was placed in equestrian therapy as a young child due to experiencing auditory hallucinations. Kevin Gregg refused to cooperate in Carly's defense, refused to talk to the state, and refused to talk to the mental health professionals who were evaluating his daughter. So not a lot of help he was. But now her defense team has learned this information after the fact, that she was hearing voices. And that, of course, could go to her mental state at the time of the incident. Let's talk about what this means with retired criminal defense attorney Kirk Nurmi, the man who famously saved Jodi Arias's life. Kurt, good morning to you. Oh boy, tell me your first thoughts when you heard that there was this newly discovered information unavailable to either side at the time of trial.
Good morning, Julie. Yeah, it's interesting, and it's not really surprising in the sense of what we learn about, right? We know that at her young age, to do what she did, there had to be some mental health issues. There had to be some trauma. There had to be something going on here. And now we're starting to see the beginnings of that in this motion. What her biological father could say could be very enlightening to her, maybe not her mental state at the time, but her mental health history, which touches on the idea of her transfer to adult court, as well as the viability of any defense. So given that an appeal, as we both know, Julie, and to remind the viewers that any appeal is limited to what's on the record, the defense felt compelled, probably not thinking that they're going to win this motion, but compelled to put this on the record to flesh these things out so that when that case goes up on appeal, the Court of Appeals has a full record before them.
Important distinction you just made, Kirk. Thank you for that. So this motion is to the trial court. This is post-conviction relief with the trial court, where she had her case, not yet up going to the appellate court, as you noted, which this is going to lay the groundwork for that potentially. Thank you for that. Kirk, so in this motion, it goes on to say that this new information from Carly's dad, Kevin Gregg, supports Dr. Andrew Clark, the forensic psychologist, their expert witness. It supports Dr. Clark's diagnosis of unspecified schizophrenic disorder, and it's likely to lead to a different result at a new trial. Dr. Clark testified to some of the writings in Carly's journal. I'm sure many of us remember that. Let's go back to that moment in the trial together now.
March 12th, Tuesday, she writes, "I think I had a psychotic break earlier. The whole ordeal was quite silly. I actually spoke with one of the voices in my head. Well, I didn't hear them until earlier today, but I only do then. My particular friend and I were practically screaming, bloodthirstily and ravenously. Thank God, physical confrontation was not, and I think it's fruitively, possible. I sound crazy."
Kirk, we know Dad is saying that she heard voices. He's corroborating this. How much more weight, I guess, is this testimony from Dr. Andrew Clark given in light of the new information from Dad?
Well, certainly a little more, but I think, Julie, this is also a fertile ground to get more information. I mean, anytime anybody's making a psychological diagnosis, they want more information. And I hearken back then to this mention of her getting equestrian therapy at a young age. What motivated that? Did a doctor recommend that? What records does the equestrian therapy facility have? What documentation, what doctors looked at her? Because all that is important data in a psychological analysis, and so that could be very important in terms of fleshing it out, maybe even altering both psychologists' opinion to a certain degree. That's why I think this motion is so well taken.
Kirk, thank you for that. Great points. I have a clip of that interview that Kevin Gregg did with WLBT TV station. Let's take a look at some of it now.
That girl is not insane. That was a very dumb defense, if you ask me. But I wasn't involved. Nobody ever called me. I don't want to judge her. I hope she finds Jesus. I hope she can reconcile with what she did.
So I know that first clip was quick, but he's saying that she knew right from wrong, that she wasn't insane, and that he called it a dumb defense. And then he also says that nobody talked to him about it. And Kirk, you know, ironically, if you're on the defense side of this, he could have really tipped the scales for the defense, don't you think, if he would have talked about the hearing the voices, one more person saying that she may not have been totally clear at the time of the crimes?
Well, it seems like the defense has taken a different position, that they did try to talk to him. They said that he did not talk to the state as well. So, you know, when people are in interviews like this, they may be trying to project a certain something forward that may not be entirely accurate. That's why I think I've always found experience is guides me towards the unedited portions. What else did they say? What have they said in other forums? So yeah, to me, Mr. Gregg's comments don't ring very true or very solidified. I want to see those records. That's what matters to me if I'm the defense.
Right, Kirk, great point. So I know that it's early. This motion was just filed. We don't have the benefit of seeing a responsive motion yet from the state. But your thoughts, of course, everybody wants to know, is she going to get a new trial? How likely do you think that would be?
I think it tends to be very unlikely. You know, appeals probably have a less than 5% success rate. And in a case like this, a motion for new trial, because again, as you said earlier, we're not at the appellate court, we're in front of the same judge. So unless they were to find really compelling information, and by that probably I mean those records from the Equestrian Center, if they could have an expert come in and say, this could alter my opinion, or perhaps question the state's expert to say, would this alter your opinion? Then that could otherwise motivate a judge. But at this point, it's likely more a matter of building that record for the Court of Appeals, because a judge is unlikely to overturn their own rulings and what have you. So it's really a less than 5% chance, Julie.
This is really helpful. Kirk Nerby, you're awesome.
And I gotta agree that Kirk Nerby is awesome. He's broke this thing down better than I thought he could. Special thanks to him and Court TV's Julie Grant for their coverage on this. And now I see why the dad didn't participate at all in police defense, talking to the state, talking to the mental health expert. Or he wants to see what's best for her, but he wasn't gonna abide by exactly everything she did. So as far as the the new evidence, possibly looking for a brand new trial, possibly setting her free. We'll just have to wait and see what happens with that. But as far as I'm concerned, I don't think either should happen. Next up, we're going to talk. We're going to bring about Hannah Gutierrez's conviction being upheld in the shooting on the set of the movie Rust. And believe it, and trust me, I have a problem with this. All right. Okay. Here's what we got. A New Mexico judge on Monday upheld an involuntary manslaughter conviction against a movie armorer in the fatal shooting of a cinematographer by Alec Baldwin on the set of the Western film Rust. Armorer Hannah Gutierrez asked the court to dismiss her involuntary manslaughter conviction or convene a new trial in the shooting death, alleging misconduct and suppression of evidence by law enforcement. Judge Mary Marlowe Summer halted and ended Baldwin's trial in July based on misconduct of police and prosecutors and their withholding evidence from the defense in the 2021 shooting of cinematographer Helena Hutchins on the outside of Santa Fe. Gutierrez was convicted by a jury in March in a trial overseen by Judge Marlowe Summer, who later sentenced her to the maximum 18-month penalty. Gutierrez also already has an appeal of her involuntary manslaughter conviction pending in a higher court. Now, I stopped there so I can bring you the report from Court TV's Ted Rollins and Julia Janae. So stand by, ladies and gentlemen. Here we go.
Breaking news at this hour. You remember Hannah Gutierrez, through her attorney Jason Bowles, was asking the judge in the case against Alec Baldwin and Hannah Gutierrez in New Mexico for a new trial, or at least to be let out on bond during the process of her appeal. She was sentenced to 18 months in prison for her role in the death of cinematographer Helena Hutchins on the movie set of Rust.
Right, we saw all of this play out last week with pretty intense arguments on both sides. The prosecution arguing that no, she doesn't deserve a new trial, that she had all of the evidence and her attorney was in possession of or had access to those live rounds that were discovered after her trial, sent to police. Troy Teske had them, and we now have the response from the judge, where the judge is denying that motion for a new trial for Hannah Gutierrez, and also the motion that she made through her attorneys for immediate release from detention pending her appeal. So she's still serving out that 18-month sentence behind bars.
And it's probably not surprising, given if you go back to the trial against Hannah Gutierrez and her sentencing. When she was sentenced by Judge Mary Marlowe Summer, the judge looked her in the eye and said, you and you alone are responsible for turning a safe weapon into a deadly weapon. There was real emotion coming from the bench on that sentencing, and the trial, not to get into the weeds too much here, but the case against Alec Baldwin was thrown out because of something that came to light after Hannah's trial that the defense knew all about. I mean, this was a guy, this Troy Teske guy was a defense witness. They decided not to call him, and this, you know, he was former law enforcement, so he didn't want to bring these rounds back with him to Arizona, drops him off at the sheriff's department, and that's how we got to Alec Baldwin's case.
And the prosecution not taking them, testing them, not handing them over to the defense in the Alec Baldwin case, and that's what ended in the dismissal. But you can
but it really had nothing to do with Hannah Gutierrez, right? I mean, they knew about the rounds. They knew about, they're the ones that brought Teske in. They decided not to use them.
And there were additional things that Jason Bowles, the attorney for Hannah Gutierrez, brought up. There were some interviews. There was, I believe, the third Seth Kenney interview that they didn't have. That even on this this hearing that they held, Carrie Morrissey admitted, yes, we did not turn that over. We should have. There was something that it was a mistake, an honest mistake. So apparently the judge didn't feel that it was to the level that it was in the Alec Baldwin case, where something didn't get turned over in time for trial.
Still with us, Tad Thomas, trial attorney in Kentucky. Tad, this was expected by some, but yeah, you never know. The momentum after the Baldwin debacle could have carried into Hannah Gutierrez's case, but didn't. Your thoughts?
Yeah, you know, it's you're entitled to a fair trial. To have a fair trial, you're entitled to have all of the information that the prosecution is going to level against you, and all exculpatory information that may be out there that is in the hands of the prosecution. You know, what the court has said here is this was a fair trial. He had all this information, her attorneys had all this information. They chose not to take the same direction that Alec Baldwin's attorneys took. And it doesn't make a difference in her case because the prosecution of her as the armorer is very different than the prosecution of Alec Baldwin. As the judge said, and you adequately point out, you know, she was the one that was responsible to make sure that this was not a live round weapon. It doesn't matter what all these, extracurricular things are that are going on. This was on her, and she dropped the ball.
So the next step will be for her attorneys to file an appeal in this case. They had to cross this hurdle. You have to get the trial judge to say, no, you can't have a new trial. But they also wanted her to be released pending her appeal. Do you think it's possible that the appeals court will allow that? Because she's got this short sentence. It could take a long time for the appeals court to even figure out what they want to do with this case.
It's possible, but once it gets to the Court of Appeals, first of all, it's a very unique remedy that she would be released pending appeal by the Court of Appeals. They're going to look at it, and if they don't see some palpable, on-the-face error by the trial court judge, they're probably going to leave it alone. Most appellate courts defer to the trial court unless there's just something obvious that stands out there. The fact that this is only an 18-month sentence, that certainly leans to her favor, but it's going to be very unusual, and I'd be really surprised if the Court of Appeals lets her out pending appeal in this case.
The Alec Baldwin case seemed to have gone away, but Carrie Morrissey, the special prosecutor, has petitioned the judge to reconsider her decision on dismissing the charges against Alec Baldwin with prejudice. That, to Julia's point, is also a step to go to the next level, because there's no way she's going to have a change of heart at the trial level. But are you surprised that the special prosecutor Morrissey just let this thing go in terms of the Alec Baldwin side of the equation? Because there did clearly seem to be a misstep in the handling of the evidence.
You know, one of your other guests that I've seen on, I can't remember her name now, that was worked on this case at one point, said it pretty clearly when she talked about this prosecutor's personality and how she goes about handling her cases. And so it doesn't surprise me, given that inside information about this prosecutor's personality, that she absolutely wants this conviction. She's going to do anything that she can to get it. And, Katie barred the door on all process procedure. So, no, it doesn't surprise me that this is the tactic she's taking. However, I don't know that the results are going to be very good for her here.
Yeah, or Linda Johnson is who you're referring to. She was the co-counsel for that. We just recently interviewed her last week for an upcoming victim verdict a week from Sunday on this case, and boy, she has some very interesting things to say. In fact, she said that once the live rounds were pulled out of the bag by the judge, she had the uh-oh feeling, and as she said, she just felt disgusted and went to the bathroom and was basically pacing back and forth, wondering what should she do. Should she resign? And the way she tells the story, it's incredible what she went through. Ended up writing on a Post-it note to Carrie Morrissey, I'm resigning, because they had reconvened before she, by the time she got out of the bathroom, they had reconvened. She's in the courtroom. She writes on a Post-it note.
And you were inside the courtroom, right?
Yes,
during that time, we were all watching along and not knowing what was going on. And it seemed like the reports were that she had resigned, but it was while the hearing was going on in front of the judge.
Yeah.
So it was
She ends up walking out. She left her bag and her computer. A bailiff had to come and get it. It was high drama.
And unusual. The entire situation was unusual, almost at every level, Tad. Just the charges, because we hadn't seen an actor of Alec Baldwin's caliber being charged for something like this. It was already an unfortunate situation, the death of Helena Hutchins. But who pays for it if the special prosecutor wants to keep appealing higher and higher on this case? Who makes the decision? Because she's not technically with an office that would have ranks of people who she would have to go through as a special prosecutor, correct?
Yeah, it's, whoever appointed her is going to have the ultimate decision as to whether or not this continues and what money she can spend. And so she could be cut off. But, just with what you were saying with Linda, kudos to her. We're often put in situations as trial lawyers in the heat of battle when things come up, and not only do you have to consider what is in the best interest of your client, but what is ethical and what you can and can't do. And so for her to take that move in the middle of trial, and when that's going on, that is a hard decision on her part. So kudos to her for doing the right thing, the thing that she believed was the ethical thing in front of that court at that time. That's a hard call.
Mm-hmm. Yeah, and you can hear her tell that story on Victim to Verdict next a week from
on
Sunday,
Sundays.
8 o'clock Eastern. Let's get a break in here. Again, the breaking news: no is the answer to Hannah Gutierrez's motion for a new trial. The judge in that case denied that motion, so she will continue to serve her sentence, at least for now.
Now, at the beginning, I was ready to say I disagree with this, but now I kind of see the strategy in it all. That that the judge would have to say no, I can't, I will not grant a new trial. No, I will not set you free because of something that happened in another trial. That way, there is still the option of getting that case appealed in a higher court. So now that takes care of that'll set everything else in motion. So we'll see what happens in Hannah Gutierrez's case, as this drama is not over with, not by a long shot. And we're going to go to our first sentencing of the evening. This is the end. I'm calling it like it is, the end of the protective grandmother case, Nevada versus Pamela Bordeaux. She was convicted of fatally shooting her former son-in-law, Sean Babbitt. And now we get to hear her fate decided. All right. right, now that I've got that set, I'm going to keep the disclaimer there.
All right, so we'll call page 1, Pamela Bordeaux, C340404. This is the time and date set for sentencing. Are the parties ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Okay. This is a sentencing pursuant to a jury verdict. So state you have the right to argue.
Thank you, Your Honor. Based upon the fact that you have lived with this case for as long as the rest of us, that you did see the jury trial, that you saw all of the evidence against the defendant, I will keep this brief and reserve time for the family to speak.
How many victim speakers will you be calling? Just so
I believe one, but I think other members may decide during the course of today whether or not they'd like to speak, but at least one.
Okay, sounds good. And they were noticed, and so if there's any objection at the time to...
There's none.
None. Okay, perfect. Okay, go ahead.
So the state will recommend today a sentence of 28 years to life, Your Honor. As we stand here now at sentencing, I think that what is most profound and what strikes the state the most is the stunning lack of remorse shown by the defendant. As I read through the sentencing memorandum, we are faced with the exact same lies, the exact same delusions that were presented to the police, that were presented to the jury, that were presented to this court by way of motion for a new trial, and now ultimately that are presented again by way of a sentencing memorandum. Ms. Bordeaux has failed to show an ounce of personal responsibility, an ounce of remorse for what she did, for the fact that in cold blood, she killed a man, the father, I might add, of her grandchild. While she may not think that this man was worthy of having a relationship with this boy, the boy may. Other members of the family may. And as he grows up, he will not have that right and that choice to have a relationship with his own biological father because of a unilateral decision that Ms. Bordeaux made. The entire trial, the entire lead up to the trial, and now even in the sentencing memorandum, this is an indictment on the victim, and it's based on her delusions and her lies. Really most telling is this evaluation that the defense had done by Dr. Garrison. And it wouldn't be relevant but for where we are today. Dr. Garrison is this evaluation that the defense, it goes into that as to why she's asked evaluation comes from Ms. Bordeaux. It's either text messages taken out of context that are personal and private between a husband and a wife, okay, where there's multiple layers of context that goes into that as to why she's asking the questions that she's asking and why he's answering in the way that he's answering. Completely taken out of context. Taken out of context. In the record, somewhere in the in Odyssey, in our court filing systems, somehow the media gets that. Like, how in the world would the media find that particular filing, that particular expert notice, if not given to them? Then there is this tabloid-worthy report done by the media that basically verbatim says what Dr. Garrison's report says that is riddled with lies. No attempt to verify anything that is said in there as truth. Okay? An obvious ploy to get to the jury, an obvious ploy to poison our jury pool in favor of Ms. Bordeaux. Again, why is it relevant today? Because even today, after the jury has spoken, after the jury has rejected the defendant's defense, and much of what the defense was doing during trial, right? Like, they're not stupid. They obviously knew what these little innuendos were through trial of, like, there's more than you that meets the eye. You guys know there's more to this. They knew exactly what the defense was doing. And they wholly rejected it. They were offended by it. And they said that's not what the evidence shows. What the evidence shows is that she sat before this jury on the witness stand and she repeatedly lied to them with a straight face. And they know it because they were smart enough to compare the evidence that they saw in that house, and they knew that it was in complete contradiction with everything that Ms. Bordeaux said. So even after this jury has spoken, the defense puts forth a sentencing memorandum based upon each and every lie that she has told since the inception of this case. Why? Because she acted as judge, jury, and executioner in this case. She made the unilateral decision that this man and this child should never have a relationship. She's deserving, frankly, of life without the possibility of parole. I will not suggest that to this court. I understand that she, up until now, has led a life free of crime. That doesn't mean it was free of manipulation, and it doesn't mean that it was free of delusion. It was free of criminal activity. Okay? But what she did in this relationship, what she did to this couple, what she did to her grandson, what she's done to her daughter, for the rest of their lives, that manipulation, they will have to live with that for the rest of their lives, notwithstanding the fact that this man is no longer in their lives, or that he's been taken from his parents, his siblings, his friends, and of course his son. So, this was a premeditated and deliberate murder. We know that based upon the evidence. We know that based upon the fact that she staged the scene before, that she closed those blinds that she never had closed before on one of his visits. We know the fact that she manipulated that crime scene. She took a sock off of a dead man. She used it to manipulate those cartridge cases exactly where the defense would need them to be had the shooting occurred, as the defense tried to say. It flew in the face of the physical evidence. The jury knows it, the court knows it, and we would ask for you to sentence accordingly.
Mr. Ferran, did you want Ms. Bordeaux to speak first, or did you want to speak first? Ms. Bordeaux, is there anything?
Would you like to speak?
No, thank you.
Okay. Mr. Ferran, I did review your sentencing memorandum that was filed yesterday. Thank you for including especially the letters of commendation and everything. I think it's very clear from that she was an exemplary police officer. You may proceed.
Judge, I don't want to, as Ms. Fox said, I don't want to relitigate this case. You know my position, and it's been from the inception of this case. As a practitioner for these courts for 20 years, Judge, I wouldn't suborn the manipulation of evidence. I wouldn't have presented that defense if I didn't believe it, if I didn't think it was the right defense. That doesn't mean that Ms. Bordeaux is not remorseful for how it played out or what happened. The two positions are divergent, right? She, in all of her heart, wishes this would have played out a different way, wishes she would have acted differently, wishes probably the scenario would have been different. These people probably should have gone via a different route as opposed to having someone so close supervise. I'm not imputing any blame upon Sean. Judge, the jury came back. The jury came back. You can't change that. It doesn't mean she doesn't accept responsibility. She's here, Judge. She's got legal options in the future. That has nothing to do with today. She accepts responsibility, Judge. My sentencing memorandum resubmits my position, Judge. And Your Honor is well aware, we don't need to go into the many motions that were filed, the many discussions that were had, and what happened during the trial, Judge. What I want you to look at is the other side of the token. Right? Ms. Bordeaux has led an exemplary life. One I think that most people would dream of. A single woman, taking care of her child, raised her, put her through school, helped Sean be put through school, wanted him to succeed in every way, Judge. You know, she was in the armed forces, right? She was in the military, again. She decorated, discharged honorably, Judge. And then as a police officer, serving in this very community, made her way all the way up to detective from civilian. It was extremely odd. You saw the letters of commendation, Judge. This is the woman who went above and beyond to save lives. All I'm suggesting to this court is, I understand the dual needs of our system. Judge, punishment and rehabilitation. Looking through the sentencing memorandum, seeing her as we sit here, understanding even the state's arguments here, Judge, and while they attack and again bolster their position and restate it with good cause, that's what the jury came back with. Even they understand that there is value to Ms. Bordeaux. There's a rehabilitative value. Judge, we should move up on her. And like you say, some things are just unforgivable. You know, I always use that because it's one of the most interesting things I've heard in murder sentencing. It is unforgivable. Judge, doesn't mean that we forget about her and don't give her a chance, right? We sentence based on body of life, priors, the thought of recidivism in the future, right? That's what we sentence on, right? And if you look at from her birth until this happened, Judge, and understanding her personal, the way she was raised, Judge, without a father who was present, by a single mom, became a single mom, you know, did all her stuff, but did it extremely well until this moment, Judge. So this obviously changed everybody in this courtroom's life, Judge, and I can't take that back. She can't take that back. It doesn't mean she's sorry, and it doesn't mean that she doesn't get a chance at rehabilitation, given the body of life, the body of evidence that we have before us today, including 20 plus years in her personnel file with Metro, Judge. So I'd submit with that, Judge. I would ask for her, obviously, since not life without, Judge, and the state has asked for a fair sentence, Judge. Obviously, my heart's desire would be lighter, and I don't mean that with any lightness or levity, but I just say that because of her age, Judge. So obviously, at her age, 28 years is a life sentence, regardless, Judge. So I'd ask for turning to life and then the minimum on the deadly weapon enhancement, Judge.
All right, thank you. State, you may call your first victim speaker.
Thank you. Christopher Babbitt will be speaking. He's ready right now. You do solemnly swear the testimony you're about to give in this action should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please state and spell both your first and last name.
Christopher Babbitt, CHRISTOPHER, BABBITT.
Thank you.
Mr. Babbitt, I know you've been present for a lot of proceedings in this courtroom, and now is your time to speak. You may be heard on the impact that this crime has had on your life.
Thank you. I am going to read a statement that my mother has prepared on her behalf.
Okay.
Do you need her name also for the record? Or?
No, it's fine. You can just, or if you want to just let us know her name so we have it, but she doesn't have to be sworn. Perfect.
And this is my mother's statement. I appreciate your forbearance. This is me. I haven't had any sleep since yesterday, and this is very difficult. Yeah, thank you. The tragedy of Sean's death is that it need not have happened. The senseless loss of life and love. We have carried this grief around like a cloak that envelops us in heavy sorrow. As many times as we don the cloak, it never gets easier. Sean's last day was filled with joy, love, and hope. He and I had valuable discussions of which I am so thankful. It was a Golden Knights and Game of Thrones Easter Sunday, and Sean was teaching his nieces how to roll a hula hoop. To have that taken away is heartbreaking. To have it done so because of Pam's lack of courage or presence of being to engage in conversation to achieve a peaceful and civil resolution instead of violence is that much more life-altering. Our family has managed to stay strong in love. And I leave this poem for Sean's journey with friends and family. For the unfamiliar roads we have passed, the strangers we have helped, the anxieties we have overcome, and the promises we have kept, for the regrets, for the loves we lost, for the fears we met, for the memories that ache and the hope that remains, for the joy that we celebrate and the sadness we hide, for the love and happiness and the wild pursuit of our dreams. May we all become stronger and prouder and better and genuinely grateful, for there is much more to come. And that is my mother's statement. I have not prepared a statement, but I am making one. Because Citing used to go to pieces like this. But my little brother is not just my favorite person and my best friend, but he was the other side of my coin. He was my soulmate. And having him ripped from our lives is a void that does not fill. It's not something you can fix. Like she says, it's not something... This is forever. This right here is how I've woken up for 3 years. For 3 years I couldn't wake up and not be this way. Trying to hold it together for my family and my children. And my wife and my 2 children are the only things in my life that are not inextricably linked to my brother. Every source of joy and happiness and everything that provides me the succor of what life is to live was linked to my brother, and I shared with my brother, who was closer than a twin for me. And it's gone for nothing and for no reason. And this is the only time I can say that I'm not the only one who feels this way for him. At his memorial, hundreds of people came from across the country. People tried to come from out of the country and couldn't get visas because of the impact he had on them. He was one of the most selfless and kind and brilliant people I've ever known, and I'm the big brother, and I aspired to be like him in so many ways. And I have lost a shorthand that I can never regain with anyone because of our shared life experiences. Everything that I love, that I'm excited for, I can't share with him. And it's torn away, and it just becomes another reminder of how he's not here. And there's nothing that will ever fix that. And I want to thank the council, the state's representation for everything they've done and everything they've been able to say, that much of which our family was not aware of whether it was appropriate for us to address. So thank you for that. But I love my little brother. And he should be here with us right now. And that's all I'm saying.
Thank you, Mr. Babbitt. I appreciate you telling me more about your brother, and also I think that was a perfect encapsulation of how forever this is. State, anyone else want to speak? Want to come up? Please turn it, sir.
You do solemnly swear the testimony you're about to give in this action should be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please state and spell your first and last names for the record.
Dan Mandarino, DAN MANDARINO.
Thank you.
Thank you, sir. Whenever you're ready.
I'd like to thank Your Honor for presiding over this case so fairly and so strong. I would like to say that this is a culmination of 5 years of anguish, but I can't. I have to go back 16 years with the people that murdered my son. To say that, and I don't know how many parents could tell a kid to please get away from that person, but we begged him to get away from these people. We knew they were so bad. But he wouldn't listen. When that happens, and you're a parent, you can only hope that your child doesn't get harmed, because you can't stop them. I can honestly say, without ever telling my wife, I planned on kidnapping my son to get him away from these people back in 2008 and taking him to Italy. But I thought that would be bad. But now that I look at it, I think it would save his life. The case you were presented was not what went on. It was enough to convict, but the torture they put this boy through, I believe back in 2014 when his wife, my ex-daughter-in-law, was having that affair with that.
You can continue, sir.
Was having that affair, the plan went into effect. The big lie that was told during court was that that life insurance policy was taken out because there was a child involved. And that would be normal. And I agree, that would be natural. However, if you look into the testimony of the insurance salesman, that life insurance policy was taken out in June of 2014. But the child was born in August 2015. Unless gestation period is 15 years, 15 months, there was no child involved. But there was a plan. There was a plan. I'm convinced of that. Sean, what you don't know is, we know, but you could tell that they kept needling. Okay, you get 1 hour starting at 7 o'clock in the morning, which is totally ridiculous and absurd for anyone. I think any reasonable man would say those aren't good visiting hours. We get, oh, but I have to be at my mother-in-law's house when this happens. Of course, because she was the one that believed she could just kill anyone in her own house. And I think she always believed that. Even to this day, she doesn't understand why she can't. They needled him. His final act, and what was never brought up in court, was they wanted to change the child's last name to the person that was having the affair. The person that, so Sean says, no, you're not taking my last name from the son. And that's when he got the attorney. That's what moved him. They kept nudging him until he made a move. Now, when you look at the picture, it's evident to me that was the kill zone where he was killed. They had to set that up so that front door didn't lock, so that bathroom door didn't open. They wanted him trapped. She started shooting him she was on the top of the stairs, and he was, as soon as he hit that bottom step, she started shooting him. He's turning, that's when that bullet enters here. She never left the stairs. She went from the top to the bottom. When you see him laying on the ground, if you lift his body up, he's facing the stairs. That's where he was killed. When she shot him, then the final one went through the head. She never left the stairs. She drops the gun. It's right at the bottom of the stairs. It was a kill zone. It was horrible, and it was planned months, years in advance of where it was. I'm convinced of that. And this is the torture I had to go through. And I have to live every day knowing that these people put my son, that put him in a kill zone to kill him. That's very, very difficult. I have to wake up in the morning seeing my wife cry on Mondays, especially on the Monday after the Easter, the day he died. Just bawling because of this. I would ask for the maximum that you could possibly give to her, because this is more than just premeditated, what you've said. I know you have to go by the guys, but when we got Sean back, we got him back in 2015. He was like 160 pounds, and he shook like this. For 3 or 4 months, we were very concerned about his nervous condition. This has been hell, but that's what you get when you deal with people like this. And this is what we have to live with for the rest of our life. Thank you for listening to me.
Thank you, Mr. Mandarino. I appreciate that insight.
And that's the conclusion of the speakers, Your Honor.
Okay. I mean, I think it's very clear that Ms. Bordeaux, while excellent in her role as a police officer, was a terrible mother-in-law and ultimately a grandmother to her young grandson, because she took away the opportunity for any sort of relationship for him to ever have with his father. This case is sad in many ways, and I know that no matter what I sentence Ms. Bordeaux to, that's a life sentence de facto. I mean, I get that. It also seemed incredibly premeditated, and I think the ballistics told the whole story here. In accordance with the laws of the state of Nevada, Ms. Bordeaux, you are hereby judged guilty of first-degree murder with use of a deadly weapon. I will impose the $25 administrative assessment fee, $3 DNA collection fee, $150 DNA fee, as well as the test. There will be a total of, $3,888.56, as well as $380.95 restitution to Nevada victims of crime. As to the first-degree murder portion, you are hereby sentenced to 20 years to life in the Nevada Department of Corrections. As to the deadly weapon enhancement, I've considered the factors laid out in NRS 193.165 A through E, and I will fix that at a consecutive 4 to 10 year sentence. The aggregate sentence will be 24 years to life in the Nevada Department of Corrections. As to the credit time served, 177 is what she's entitled to. I did read in the sentencing memorandum your request for the time that she spent on house arrest to be awarded toward that sentence. However, the Nevada Supreme Court has made very clear in State of Nevada versus Second Judicial District Court 121 Nevada 413 that that house arrest time doesn't count toward credit time served. So I'm going to deny that request, and the 177 will be the days credit time served. You are remanded to serve that sentence. Thank you.
Thank you very much.
We'll be in recess. Thank you, everyone.
And yes, that's it. There you have it. Amy Cruz showed up in my chat, and yes, that's the lady who capped her son-in-law, for lack of a better phrase. A former cop sat there and lied on the stand. Lovely. Well, she gets to she gets to pay the steep price. Alright, she was convicted of first-degree murder for the fatal shooting of 32-year-old Sean Babbitt, and she is sentenced to 24 years to life in prison. 24 years to life. I will be reading her last rites later on, but I mean, come on. It's bad. I mean, it's bad enough. You were a retired police officer, but that should not give you any right at all to shoot and kill someone you once considered family. But this is where that ends up, and this is where we are at this point. Alright, it is now time for a brand new edition of Diddy Do It? The article coming from Tuesday is that a woman alleges pregnancy by rape in a new lawsuit. This is why I titled this edition of Bethea'S Byte Reloaded, more cases, more updates, and more Diddy. Before we go to Court TV's Michael Ayala for this Diddy update, I'll bring you part of the article saying this: that Sean Diddy Combs was hit with a new sexual assault allegations on last Friday, as a woman filed a lawsuit in New York saying she was repeatedly sexually assaulted and drugged at the music mogul's homes and became pregnant after one of the encounters. It's the latest of several of several similar lawsuits by women against Combs, who was also arrested the week before on federal sex trafficking indictment. The lawsuits filed against Combs, his companies, and several associates, and seeks undisclosed damages for physical injuries, severe emotional distress, humiliation, anxiety, and other harms. A lawyer for Combs, his company, and one of his representatives did not immediately return emails seeking comment on last Friday. Not this past Friday, but last Friday. The woman identified in the latest lawsuit under the pseudonym Jane Doe accuses Diddy of sexually assaulting her while she was unconscious from drugs, and it alleges that Combs and his acquaintances recorded sexual encounters without her permission. She says that she met Combs overseas in the fall of 2020 and that the assaults and harassment continued through July of this year. Alright, let's get ready to go right now to Court TV's own Michael Ayala for more on this impending lawsuit.
All right, developing in New York now, rap music mogul Sean Diddy Combs is facing yet another lawsuit. This time, a woman alleges that he drugged, raped, and impregnated her. Now, the lawsuit claims in part that while in Combs' bathroom, Jane Doe was compelled to ingest a substance. Jane Doe later learned it was or contained the drug ketamine and or other substances, which caused Jane Doe to black out and lose consciousness intermittently throughout the night. Jane Doe did not consent to ingesting ketamine and or other substances. The lawsuit goes on to say when Jane Doe informed Combs that her pregnancy test came back positive, Combs' associate, fellow rapper Young Miami, whose real name is Carisha Brownlee, harassed the victim by repeatedly calling her and telling her to have an abortion. Well, the alleged victim says the pregnancy ended with a miscarriage. She also accused Combs and his team of coercive and abusive tactics. Combs is currently, of course, in jail awaiting trial on federal racketeering and sex trafficking charges. His attorney, Mark Agnifilio, he appeared in an hour-long TMZ special speaking on the case and revealing the possibility of his client taking the stand at trial.
I don't know that I could keep him off the stand. I think he is very eager to tell his story, and I think he will tell every part of his story, including what you see on the video. So I expect it's going to be explained by the both of us.
All right, let's bring in our guest for this hour. Joining us to discuss is former prosecutor and defense attorney David Bruno. We have him now. And of course, criminal defense attorney and former prosecutor Marie Pereira, who's here in studio with us. David, I'll start with you. I want to get your thoughts on this new Puffy allegation, this new lawsuit, and what role, if any, might it play in his federal case?
Well, when it rains, it pours, and Puffy is getting it from all angles right now. It's interesting because he's got a dilemma. You know, he has all these civil cases going on, and if I were his attorney, I'd try to get them all stayed. But if not, I mean, he's going to have to be invoking the fifth in interrogatories and depositions because anything he says in the civil case could be used against him in the federal. But with that being said, we're seeing themes here in all of these civil lawsuits, including this one. And this is one of the reasons why Diddy has not been released, is because of these tactics that his team and he allegedly have made towards these witnesses in these other cases about pressure and trying to get influence on witnesses. That's part of the argument that the government made in the case in chief, the criminal one, at his detention hearing. So, I mean, there's themes in all of these civil lawsuits. I don't know if it's just packing on right now and taking an opportunity or whether or not they're just all coming forward now. But at one point, this will all play out. And I can't believe the attorney's coming up and saying that he'll take the stand on something like this, because criminal defense 101 is, remain silent, let them prove that case. And if he does testify, he's going to be open to cross-examination on all of these allegations.
Yeah, no question about it. And it's an interesting turn of events here, Marie. The idea that an attorney with a trial coming up is allowing himself to be part of a documentary talking about his client, and he talks about his case. I mean, these are new times.
He should exercise his right to remain silent. And I agree with you, David. Shut up. What point did it make for him that benefits Diddy for him to go on TMZ? Are you serious?
Yeah.
He's doing more damage than good. He needs to be quiet. Put your strategy together. If you're going to claim that everybody engaged in the sex fest consensually, they took the drugs, it was more like a transaction, do that. Shut up, though. You don't need to grandstand. It shows a level of unprofessionalism, too. What do you think, David? For real?
Yeah.
Like, stop it.
Yeah.
It's interesting, I agree, but these are new times, guys. These are new times, and getting your narrative out there is important. They're in the entertainment industry. They're going to entertain.
Diddy. I'm not even in the entertainment business. I've been only doing live streams of true crime stories for a couple of years now, about to go on 3. And I gotta agree with both David Bruno, who I'm shouting out, Marie Pereira, I gotta shout her out too. I'm gonna say this like somebody else in the business. And I'll break it down as best I can. Diddy, right now, your role is defendant. Know it. It's the prosecution's job to prove their case against you. So your mouth, shut it. Let the prosecution do their job. Let your defense team do their job. Because the longer you keep running your mouth, the more guilty you're going to look. So basically, shut up. That's all I gotta say about that. Be quiet. But guys, hang on, because I've got yet another Diddy update coming up before this thing is over and done with. Right now, I do have an update in the I've got in the judge who was shot and killed by his friend and sheriff. I'll bring that to you in just a bit, but first I want to bring a new trial to your attention. Now this one I love. You'll see why when I get to all the details. All right. We have an Ohio man accused of death of a medical assistant representing himself at trial. I believe we all know how that normally goes. But wait, it gets better for him. 33-year-old Quinton Nixon is accused of fatally shooting Tony Westover, age 34, on July 25th of 2022. Nixon was arrested almost a month later. Westover's sister Amy Perry told Scripps News Cleveland that Westover and her boyfriend went to an Akron home where an altercation took place, and she was shot. No motive or connection between Nixon and Westover has been reported. Perry also said that Westover texted a friend sometime between 1 and 1:30 a.m. less than an hour before she died, saying, "Something doesn't feel right. Something feels off." Westover was gunned down during an altercation sometime between 2 and 2:15 a.m. Nixon is a pro se defendant, which means he's acting as his own attorney. Nixon has also waived his right to a jury trial, meaning a judge will decide his fate. Nixon is standing trial on multiple charges, including murder and felonious assault. If convicted, he faces life in prison. So let's take all that into account now. He is defending himself, acting as his own attorney, on charges of murder and felonious assault, and he's waived his right to a jury trial, meaning it will be the judge who will decide his fate. Now, guys, you know me as a baseball fan, right? I'll run those facts back again. 1, he's acting as his own attorney. Strike 1. He's charged with murder and felonious assault. Strike 2. And instead of having a jury trial, he's going to have the judge decide his fate. Strike 3. Sit down. The prison's right over there. For more, I'm gonna put up a disclaimer. I am going to take myself
Welcome back. Let's go now to Ohio, where a trial for a pro se defendant, Quinton Nixon, starts tomorrow. But he won't be making his case in front of a jury. This is going to be a bench trial, which means it's the judge alone who's going to decide this defendant's fate. Now, Nixon is charged with the murder of 34-year-old Toni Westover. This happened in July of 2022. She was a medical assistant who was shot and killed in the early morning hours at her home in Akron, Ohio. Now, police still have yet to find a motive in this case or connection between the two. But Westover's sister told police that her boyfriend, Brian Fielders, was somehow involved. Here's what she told Scripps Cleveland about her sister and the suspect prior to his arrest.
When they got there, she texted her friend between 1 and 1:30 and said something doesn't feel right, something feels off. And at 2 to 2:15, she was shot and killed. And to the coward who did this, you know exactly who you are. And I promise that my family will not stop until justice is served. Growing up, she was the one I looked up to. She was like my second mom, being the older sister. She loved her daughter. She loved her family. She was a beautiful person inside and out. I had to see my sister laying in a casket. I couldn't even walk through the front door to go in. When I did, I screamed and dropped to the ground. I was physically ill. She was the one I looked up to. She was my best friend, and I no longer have that, and it's not fair.
Toni Westover leaves behind a 7-year-old daughter. And again, this trial for the suspect, Quinton Nixon, is going to begin tomorrow. You're going to see it right here on Court TV. Let's bring in our guest, trial attorney Krista Ramey and criminal defense attorney Marie Pereira here in studio. But Krista, let me start with you. A pro se defendant case in front of a judge for a bench trial. I mean, it's a double whammy in terms of things that seem to be more difficult at times for a defendant. Your thoughts on those two factors?
Yeah, it's the worst possible scenario for a criminal defendant. You know, if you're going to be representing yourself, at least do it in front of a jury. You've got a judge here that understands the law, that has seen people lie and tell the truth a million times in trials in his or her courtroom. So a judge is going to be on top of things in a way that jurors you might be able to charm or, I don't know, persuade differently than you can a judge. I think that a judge in a pro se defendant is a combination that is almost like a sure thing for a guilty verdict. The prosecution probably loves this, quite honestly.
Really tough decision to make, but he's making it on his own, Marie. Your thoughts on this decision to not only be pro se, but to also have a bench trial, because you have a right to a jury trial, so he had to elect this.
I think he's making a mistake, but maybe he's banking on a lack of reasonable doubt, a lack of DNA, and missing evidence that would make a judge who really goes according to the law, and like Krista says, not pulling on the heartstrings of jurors. Maybe he feels like he has some type of a defense. I wasn't there, there was no DNA there, no one saw me there, the reasonable doubt is weak, there's no motive, even though we don't have to prove motive. Even a judge wants to put the pieces together. There's no connection between him and the victim. Maybe he's banking on all of that, and maybe he's just a difficult person, because I don't know why a person accused of such a serious crime would choose to go pro se on a murder case in front of a judge like Crystal says. That is ridiculous, very, very scary. But he's the same guy who hid out in the attic, and I believe it was like an 8-hour standoff when they had the warrant to come arrest him. He didn't just come out peacefully. He made a scene, and it was a whole thing to just get him in cuffs.
So he may be a difficult client. Who knows what the backstory is, but we will learn a lot more with opening statements that start tomorrow.
He can be as difficult as he wants to be. I would not. I'm not an attorney, nor do I claim to be one. But even I would not recommend to any criminal defendant to A, represent yourself, and B, have your case played out in front of a judge. I mean, you can't get more of a double-edged sword than that. Let me go right to the chat real quick on this. And thanks. I'm glad I can make you laugh. But I mean, as crazy as it is, it's that serious, Amy. Again, you have a guy being charged with murder and felonious assault. I don't know how many times I can repeat this. Murder and felonious assault. He's choosing to represent himself in front of a judge, and a judge only. Not the 12 in the box, but the one on the bench. This ain't Vegas. If he's gambling on lack of evidence, if he's gambling on lack of evidence, and he's gambling on reasonable doubt is weak, this, that, and the third, and the evidence is there. Let me remind you one more time that if he is convicted, he's facing life in prison without the possibility of parole. Now, I say again, do you really want to take a gamble with your life like that? I'm just saying. Next on the docket, we have an officer who has now been decertified over ties to Sandra Birchmore, while his twin brother is facing charges. A former police officer's certification has been permanently revoked over his involvement in a case that has his twin brother charged with killing a woman both brothers had been seeing. William Farwell, who worked as a police officer at the Stoughton Police Department for 5 years, entered a voluntary decertification agreement with the state, meaning he can no longer work as a law enforcement officer. His decertification will also be added to the National decertification index, which means he can't work as a police officer anywhere in the United States. While William is not facing any criminal charges, his twin brother Matthew was indicted on federal charges that he strangled his pregnant mistress Sandra Birchmore to hide an affair that began when the victim was underage. Matthew is additionally accused of staging Birchmore's death to appear as a suicide. So, let me make sure I got it. Okay, I got the I've got the copyright I got the copyright up. Good. So I'm gonna go ahead and take myself out the shot, and I'm gonna take you right back to Court TV, and I believe this one's on Julie Grant. She'll update you more on this.
Welcome back. In our spotlight this morning, we've got some shocking new information that an ex-cop had a sexual relationship with the woman that his twin brother is accused of murdering. Former Stoughton, Massachusetts police officer Matthew Farwell is already charged with the murder of 23-year-old Sandra Birchmore, who was believed to be pregnant with his child. Federal authorities allege that Farwell strangled and killed Birchmore and then staged her death to appear to be a suicide. Well, now Farwell's twin brother, William Farwell, who also was an officer with the Stoughton Police Department, has been decertified and can never, ever again work in law enforcement. This after court documents reveal that he also had a sexual relationship with Birchmore. In fact, listen how disgusting this is. Allegedly having sex with her just days before her murder. Remember, she's pregnant with his brother's child, as authorities believe. To just let that sink in for a second. Now, and the allegation is that he also knew that she was pregnant with his brother's child. Now, at this time, William Farwell is not facing any criminal charges, but he and his brother and the former deputy chief, Robert Devine, have all been accused in a civil lawsuit by Sandra Birchmore's family of sexually grooming her when she was a minor child. She entered the Police Youth Explorers program when she was just 13 years old. Now, her family has filed a wrongful death lawsuit naming all three men and the Stoughton Police Department, I believe in her early 20s at this present time. But the allegation in the civil suit is that this grooming was going on when she was a minor child. How filthy, disgusting are these allegations? They're stomach turning. Let's bring in our guest now and talk some more about this and whether this could mean some charges for brother William there. He's been decertified. Is he going to join his brother Matthew at all? Let's bring in Chief Chris Anderson and attorney Franz Borghardt to get some insight on this. Chief, let me start with you first, please. Your thoughts.
Excuse me, this is troubling for my profession as a whole. You know, those programs, those young officers programs that we have, they have them nationwide, have been a pivotal role in recruiting and getting people to learn more about the other side of law enforcement. So it's troubling as a whole to see this kind of actions done by people who frankly should not have been law enforcement officers. But as the case goes and we learn more information about it, it gets more troubling. And I'm very, very, very disappointed by the actions of these men in this case.
Thank you for that sentiment, Chief. I know that it is certainly much appreciated by everyone, you know, who it was brought up, you know, to trust law enforcement, to believe in law enforcement, support law enforcement. It's important to note that, you know, a few bad apples don't spoil the bunch. And here we may be dealing with possibly some incredibly rotten apples here. Franz Borghardt, the family sure thinks so. The family is saying that these three groomed her when she was a young teen, 13 when she entered the program. I just looked it up, 23 at the time of her death. So your thoughts legally here. Do you think that decertified twin brother William should be nervous that he may wind up in the criminal court system like his brother Matthew?
I think he's absolutely going to end up in the court system, and I think the prosecution and law enforcement of that community need to be strongly pushing for it, because his actions, especially in the program that he was in, they have to make an example out of him. They cannot allow that kind of behavior. And look, protecting and serving doesn't mean servicing yourself. And it doesn't mean preying on the very young people that you're supposed to be helping and assisting. I absolutely think he's going to get arrested and prosecuted.
Franz, thank you so much for that. This is something we're all waiting for the other shoe to drop, so to speak. Thank you for laying that out legally. Josh Levy is the U.S. attorney in the district that would encompass Stoughton. And I want to go back to when he held a press conference fairly recently when Matthew Farwell, the brother who's accused of grooming her when she was underage and impregnating her at the age of 23 years old, when he was charged with her murder. Initially, we know it was ruled a suicide initially, and there was just talk about it in the community. Let's listen to a little bit of what the U.S. attorney told the public.
I'm not going to comment on information that's not in the public record. As you heard, this is an ongoing matter, so we're going to continue to look into this matter. And if there's other individuals that we develop evidence that they've violated the federal law, we'll proceed. At the time of her death, Sandra Birchmore was a 23-year-old woman with her entire life ahead of her, and she was pregnant with her first child. We allege that Sandra Birchmore survived years of grooming, statutory rape, and then sexual violence, all at the hands of Matthew Farwell, who was employed throughout their relationship as an officer and then detective for the Stoughton Police Department.
Now, we know that initially her death was said to be a suicide, but that didn't sit right with her friends and family because they were saying she was so excited to have her baby. She was 3 months pregnant at the time. They were saying she couldn't wait to be a mom. Nothing pointed to any indications that this young woman would want to take her own life. And then it was when the family brought in an outside expert, Dr. Michael Bodden, to review the autopsy. And Dr. Bodden said that she was strangled to death, that this was not a hanging as had been stated to be the cause of death by the initial investigators. He said she had a fractured hyoid bone, the hyoid bone in the neck that's not going to fracture with a hanging. I remember the late, great Dr. Cyril Wecht, God rest his soul. I remember him teaching me that years ago, and he said, always look, when you see that in an autopsy report, the hyoid bone, very indicative of manual strangulation. Chief Chris Anderson, your thoughts on this, how key that fracture of that teeny tiny bone could be in her neck in getting this murder conviction?
Yeah, so the hyoid bone being broken is very, very instrumental in any type of strangulation case. You know, that's one of the positions that a person has to be strangled in order for a strangulation to occur. So it usually doesn't occur when a person hangs themselves. The rope is usually a lot higher than where the hyoid bone is. But when you see rope burns and marks up in the higher position, but yet see that hyoid bone broke, it's usually a reason for a person to be very, very concerned into whether or not this case is a strangulation or suicide. Very, very good insight.
Thank you so much, Chief. You know, and something else I think is kind of interesting to note, we can end on this point, that at the time, the medical examiner who found that she died by suicide didn't send the fetal tissue for any DNA analysis. And Dr. Michael Bodden, who, you know, is outstanding. We know he may be arguably the country's leading expert in forensic pathology at this point in time. He said that they never sent the fetal tissue away to determine who the father was of the baby. Why wouldn't that be done, right? This single woman, why wouldn't anybody want to know that? Franz, final thoughts, please.
I think this is going to be a case that comes down to dueling experts. I think, while I agree that it is highly unlikely that the hyoid bone would break based on hanging, they're going to find some expert out there that will duel against the state's expert and say, well, you can't exclude that, right? It just smells very suspicious, though, right? With the DNA evidence tying this law enforcement officer to the actual victim, it gives a motive, and then it's not a very long distance to homicide.
Right, great points. Thank you both so much for your insight and expertise. Chief Chris Anderson, Attorney Franz Borghardt, thank you kindly.
As this case against Matthew Farwell heats up, we'll see if the brother ends up being charged as well. But I do have to agree with Julie Grant at the start of this one. This is disgusting in more than I can't even count how many ways. So we went through that one. Next up. Oh. Okay, here's the now we go to the update on the sheriff who killed a judge in his chambers, and it was caught on video. A detective revealed that before the shooting, former Sheriff Sean Steins discovered his daughter's number was in Judge Kevin Mullins' phone. But do I go ahead and show that video, or just do I show part of it, or let's see. Maybe there was more and they added to it. Anyway, choked sobs were the only sound in court as a silent video showed the moment a Kentucky judge was shot and killed in his chambers at the courthouse. Sean Steins, who resigned from his position as sheriff of Letcher County on Monday, is charged with the first-degree murder of Letcher County District Judge Kevin Mullins. Steins has pleaded not guilty to the charges. Kentucky State Police Detective Clayton Stamper was the first witness to take the stand at Tuesday's probable cause hearing and testified the video that showed the deadly shooting. The silent video is only a few seconds long, but it appears to show Steins coming to Mullins' chambers with a gun in his outstretched arm. The judge leaps from his chair onto the ground, and Steins appears to chase him around the desk, firing multiple times before leaving the room. Steins appears to walk over and fire another shot beneath the desk where the judge has been trying to hide. As the video ended, loud sobs were audible from the courtroom's gallery where the family of both the defendant and the victim were seated watching the hearing. Stamper testified that that during the discussion not seen on video between Steins and Mullins, Steins had attempted to call his daughter using the judge's phone. While doing so, Steins allegedly found his daughter's number already in the phone. While no further information about a possible motive was offered, Stampert said that Steins told a different officer when he was taken into custody. They were trying to kidnap my wife and kid. Judge Rupert Wilhoit found probable cause to bind the case over for a grand jury. Prosecutors said they have not said whether they will seek the death penalty for Steins. And I mean, first off, what could the judge have had on his mind with the daughter's number in his phone? I'm trying to find the 10-minute long video that I had, or maybe it was stretched out just a little longer. Apparently, I may not be able to find that. Yeah. Okay, so I'm not going to be able to play that video, but I will say this. The video evidence is right there, whether there was sound to it or not. The video evidence is there, and that video is not going to be doctored. That's security footage. If this goes to trial, Sean Steins is pretty much done. The question will be at the end of the trial will be. Two questions that'll be asked will be, does Kentucky have the death penalty? Whether the answer is yes or no, the second question is going to be, what will the former sheriff's punishment will be for shooting and killing a judge? Let alone the fact that the judge was a friend of his. And now it's time for another episode of Did He Do It? An attorney has said that he is representing 120 accusers who have come forward with sexual misconduct allegations against Sean Diddy Combs. I think I will spare you the video for this one, and I'm gonna let you decide this. I already have my opinion now, and I'll give you that in just a minute. But listen to this. An attorney said Tuesday that he is representing 120 accusers who have come forward with sexual misconduct allegations against Sean Diddy Combs, the hip hop mogul who is awaiting trial on sex trafficking charges. Houston attorney Tony Busby said he expects lawsuits to be filed within the next month, most expected to be filed in New York and Los Angeles. Busby described the victims as 60 males and 60 females, and that 25 were minors at the time of the alleged misconduct. One individual alleged he was just 9 years old when he was abused. That's according to Busby. The allegations cover a period from 1991 all the way to this year. This type of sexual assault, sexual abuse, sexual exploitation should never happen in the United States or anywhere else. This should have never been allowed to go on for so long. This conduct has created a mass of individuals who are injured, scarred, or scared. No, I'm right on both counts. Scared and scarred, Busby said at a news conference. Following the announcement of the accusations in Texas, an attorney for Combs said the performer, quote, cannot address every meritless allegation in what has become a reckless media circus, end quote. That said, Mr. Combs emphatically and categorically denies as false and defamatory any claim that he sexually abused anyone, including minors, attorney Erica Wolf said in a statement. He looks forward to proving his innocence and vindicating himself in court if and when claims are filed and served, where the truth will be established based on evidence, not speculation. Busby said more than 3,280 individuals contacted his firm and alleged they were victimized by Combs, and that after vetting the allegations, his firm decided to represent 120 people. Other cases are still being reviewed. He said some of his clients have spoken with the FBI. The individuals that Busby's firm is representing are from more than 25 states, with the majority from California, New York, Georgia, and Florida. The abuse that's being alleged took place mostly at parties in New York, California, and Florida, where individuals were given drinks that were laced with drugs, Busby said. Some of the alleged conduct took place at auditions where many times, especially young people wanting to break into the industry, were coerced into this type of conduct in the promise of being made a star, Busby said. 54-year-old Combs has been locked up at the Metropolitan Detention Center in Brooklyn since pleading not guilty September 17th to federal charges that he used his power and prestige to induce female victims into drugged up, elaborately produced sexual performances with male sex workers in events dubbed freak-offs. Other alleged victims have already filed lawsuits against Combs that include allegations of sexual assault. Combs has pleaded not guilty to racketeering, conspiracy, and sex trafficking. His attorney said he is innocent and will fight to clear his name. Combs is one of the best-known music executives, producers, and performers across hip-hop, having won 3 Grammys and worked with such artists as the notorious B.I.G., Mary J. Blige, Usher, Lil' Kim, Faith Evans, and 112. He founded Bad Boy Records in 1993, the influential fashion line Sean John, and a vodka brand, and the Revolt TV network. He sold off his stake in the latter company of June of this year. Busby has also represented women who accused NFL quarterback Deshaun Watson of sexual assault and misconduct. My friends, I'm gonna say this, and yes, this is truly a horrific case. I'm gonna say this to show you exactly where I stand at. When I first read this article in prepping for this edition of Bethea'S Byte Reloaded, I said to myself, 1 could be wrong. 2 might be wrong. But 120? There's no way. There is absolutely no way 120 people, male and female, can make that claim, and it's all about getting some kind of money from Diddy? Nah. This is definitely about taking accountability. That's over. But given the articles and the lawsuits that came before this, that's well over 120 right now. There's no way that this can be. This one's trying to get money from me. This one's trying to get money from me. No. They want you to take accountability for it, Diddy. And like I said in an earlier report, you want to prove your case? Take a great piece of advice. Shut your mouth and let your attorneys do it. Let the prosecutors prove the case against you. If you're guilty, you'll know it. But then again, you probably already do. And you're still trying to claim innocence. I'll tell you in the words of Johnny Cash, in one of my favorite songs from him, and the lyric is true. You can throw your rock to hide your hand, working in the dark against your fellow man. But as sure as God made black and white, what's done in the dark will be brought to the light. So, with that being said, I'll see you next time for another edition of Diddy Do It. Right now, got another case of a person that's up for parole. Remember the case of the woman who mistakenly who had mistaken her house for someone else's and shot the man that was inside? She was also a police officer. Well, according to the article, a former Dallas police officer convicted of killing her neighbor is now eligible for parole. In 2019, a Texas jury found Amber Geiger guilty of first-degree murder in the death of 26-year-old Botham Jean. At trial, Geiger testified she thought Jean was an intruder in her apartment when she fatally shot him. In September 2018, Geiger was off duty but still dressed in her police uniform after a long shift when she shot Jean with her service weapon. Geiger walked up to Jean's apartment, which was on the 4th floor, directly above hers on the 3rd, and found the door unlocked. The 26-year-old accountant had been eating a bowl of ice cream before Geiger entered his home, according to the Associated Press. Geiger was sentenced to 10 years in prison. She became eligible for parole on September 29th, 5 years after the verdict. In a statement to Court TV, the Texas Department of Criminal Justice said that the institutional parole officer interviews the offender and prepares the case file, which is delivered to the board panel as soon as practicable. They shall review and vote the case. There is no exact date for a board panel decision after the review. So now that you got the article, I am going to take you. I'm going to take you right to Court TV, two of Court TV's best, Judge Ashley Wilcott and Michael Ayala, as they break down this case further. And I'm going to let you guys decide whether Amber Geiger should be released on parole.
I'm an older doctor. I thought it was in my apartment, and I shot a guy thinking that he was thinking it was my apartment. He shot someone. Yes, I thought it was my apartment. Oh my God. I thought it was my apartment. I thought it was my apartment. We don't help us. I thought it was my apartment. I thought it was my apartment. I thought it was my apartment. I was on the 3rd floor. I was on the 3rd floor. It was my apartment. It was my apartment. It was my apartment. he must have come to us. I'm sorry, man. Okay, where was he shot? He's on the top left. I thought it was my apartment. I thought it was my apartment.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott.
And I'm Michael Ayala. Now to a story that made national headlines when a white Dallas police officer shot and killed a black man after she accidentally went into his apartment thinking that it was hers. Amber Geiger shot Botham Jean to death in September of 2018, sparking protests around the city.
Now, after serving only part of her 10-year sentence, she's eligible for parole. She served 5 of the years. Ironically, this comes on what would have been Botham Jean's 33rd birthday. During her trial, she testified about what happened, saying she was scared and she thought he was going to kill her.
Do you swear or affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you, please.
When you pulled your weapon at night and you fired, why did you fire?
I was scared. Whoever was inside my apartment was gonna kill me. And I'm sorry. I have to live with that every single day that I heard. No police officer ever would want to hurt an innocent person.
I have my gun pointed, and I'm saying, let me see your hands, let me see your hands.
What were you focused on?
Him.
What did the figure do after you said, let me see your hands?
He started coming towards me. I feel like a terrible person. I feel like a piece of crap. I hate that I have to live with this every single day of my life. And I ask God for forgiveness. And I hate myself every single day. I wish he was the one with the gun that killed me. I never wanted to take an innocent person's life.
When you aimed and pulled the trigger at Mr. Jean, shooting him in center mass exactly where you are trained, you intended to kill Mr. Jean.
I didn't.
Why would you try and do a little CPR on a man who's dying who needs your full attention?
Because I had to keep getting up to see where I was at.
That was more important than giving life-saving help to this man.
I had no idea where I was at.
You were able to tell the 911 call taker very, very soon on that you were in apartment 1478. After that moment, why couldn't you have given him full, undivided, and proper attention?
I was still on the phone with...
You can put the phone on speakerphone, ma'am.
I had so much stuff racing through my head.
Can you imagine Mr. Jean's perspective, an intruder barging into his apartment, somebody on the other side of that door being you, going in with the purpose of finding the threat and taking care of it, and then having been shot and fallen and being alone in that apartment? Can't you imagine that being a little bit scarier than you just being alone at the moment?
Yes, sir, I can.
Mr. Jean is lying on a stretcher being carried by paramedics, right?
Yes, sir.
You can see what you've done. The second he's passed, what do you go do again?
I looked at my phone because I didn't want to see his body.
This family is thinking about having to bury their son and their brother. 2 days after the event, you are already going back to talking about getting drunk and doing sexual things with Martin Rivera.
Yes, I did.
What was he doing when you fired the shot?
He was just moving, advanced towards me whenever I shot the first 2 shots where he ended up falling down.
And why did you shoot?
Because I was scared that he was going to come at me and kill me.
That was your reason?
Yes, sir. I was scared, and I thought he was advancing towards me. He had a weapon.
Well, Geiger was eventually found guilty of murder and sentenced to 10 years in prison. Now, before her sentence was handed down, it was the words and actions of Jean's younger brother that brought many to the courtroom in tears, including the judge and Geiger.
I hope you go to God with all the guilt, all the bad things you may have done in the past. Each and every one of us may have done something that we're not supposed to do. If you truly are sorry, I know I can speak for myself. I forgive you. And I know if you go to God and ask him, he will forgive you. I don't know if this is possible, but can I give her a hug, please? Please?
Yes.
And no date has been given yet on when Geiger will go before the parole board.
All right, let's bring back in our guest, still with us, criminal defense attorney, former prosecutor Marie Pereira. Marie, that hug, I mean, it caught everyone's attention. There was even a hug from the judge. Judge came down and hugged her as well. I don't think any one of us can question her remorse under these circumstances, but this jury saw fit to convict her of murder. What do you make of her opportunity coming up, at least we believe it's coming up, for possibility of parole?
I think she has an excellent opportunity because one of the things that the parole board is looking at is, does the person have a criminal history? Are they a recidivist? Are they remorseful? And is the family okay with it? They do take those things into account. And the fact that his little brother could hug her like that and tell her, I forgive you, go to God and ask God for forgiveness was beyond touching. And I think that is going to help her with the parole board. Parole is discretionary. So yes, a person on a parole board does have a heart and could use empathy and to see, is she a menace to society still at this point? She has a lot going for her here with the number one reason that she may get this parole is that hug right there and the forgiveness of his family.
That's true, but I'm going to push back because 5 years for murder. At the end of the day, if she gets parole, 5 years served for a murder conviction, we don't see that very often.
But you have to look at the circumstances of the crime. I do believe that she made a mistake and went into his apartment. Does her upbringing and maybe her own internal racial bias have something to do with how she reacted to him? Being a young black man, her fear perhaps made her overreact. But there was no intentionality there. I don't believe she went in there and shot him on purpose. That's not disputed. People make mistakes, and it was tragic. But I'll say again, the way that the brother forgave her and hugged her will have a lot to do with what goes on during that parole hearing, and I think she will be paroled.
Yeah, like it or not, I mean, they went through a sentencing hearing and came up with 10 years with possibility of parole after 5.
That's a good point.
Right?
You're
so
right.
that's what they decided was appropriate under these circumstances, again, taking into account a lot of the things that Marie just mentioned. And let's go over it. I think essentially when I looked it up, in Texas, the parole board will look at behavior while she's incarcerated. I can't imagine she was much of a problem, at least I'm assuming she's not. The likelihood of reoffending, you mentioned that, and also victim input. They will get the opportunity to testify or send in letters, however they decide to deal with it, to her parole hearing. So she's got that on her side, at least one would imagine, if those sentiments stay the same. The behavior was probably solid. The likelihood of reoffending. You said you don't think she's likely to reoffend? Why not?
Because she did not go into this to do it on purpose. She made a mistake. She went into the wrong apartment. How that happened, I don't know. But she didn't set out to do this. This was a tragedy. And I don't see her going out and being reckless and going into somebody else's apartment or judging somebody and pulling out a gun and shooting somebody without justification. I don't see that. Although, you know, looking at her during the cross-examination, she did switch it up and she looked rather evil and callous. And then one moment she was sobbing, I wish it was me, and I took the bullet. And then on cross-examination, she was like, yeah, I shot him, center mass, da-da-da-da. She really looked kind of shady there.
Exactly. And that's what I was going to say quickly. You know, it was a gun offense. It was a violent offense. And it was recklessness that caused death. Her reaction to the situation, and that was some of the cross-examination, was she could have reacted very differently and he'd still be alive. So that would worry me as far as the possibility of reoffending. Not that she's going to go out wanting to kill people, but that she doesn't handle situations like this stressful well.
I think that this is going to live with her forever. I think that it did not go away after 5 or 10 years in jail for her to say, I've served my time. Not that it would go away, but I've served my time, so I do feel a little bit at peace. I just feel like this is going to eat her up for the rest of her life, no matter where she is.
I do too.
All right.
As much as I like Franz, if there's anybody who can clear up a case, regardless of what the circumstances are, Marie Pereira is that one who will clear it up. My thanks to her, Judge Ashley Wilcott, and Michael Ayala for covering Amber Geiger's case, and I really hope she does get parole, because I noticed it. I noticed that between the 911 call where she said over the phone 19 times, I thought this was my apartment. I thought it was my apartment. And she ended up shooting and killing Botham Jean out of fear, out of whatever the situation was. I'm just glad. The one thing that really triggered me, and yes, they weren't the only ones in tears. I watched it, it brought me to tears too. When Botham Jean's brother, on the witness stand during impact statements, asked the judge if he could hug Amber Geiger. Not only did she allow it, after passing sentence, the judge did so as well. You know, I originally thought about doing the Darrell Brooks trial as a special edition of Bethea'S Byte Reloaded Throwback. But now that this case has crossed my mind, I want to relive this case from beginning to end. I want to see if you, being the 13th juror, would, 1, find her guilty in the same way, and 2, flash yourself forward 5 years after the sentencing. Would you let her out on parole? Let's do that. I will set up a time, and we will revisit and recover this case. State of Texas versus Amber Geiger, the wrong apartment murder trial. All right, let's move onward. Oh boy. I will spare you the video for this one, but this is a Sarah Boone update. Good. I will spare you the video. Days before jury selection begins in her murder trial, Sarah Boone took the witness stand at a motions hearing as she tried to get key evidence in her case suppressed. She faces a life sentence if she's convicted of second-degree murder in the death of her boyfriend, Jorge Torres Jr. Torres was found dead, zipped inside a suitcase inside the couple's apartment after a night of drinking in February 2020. I was very confused, very hazy, Boone said from the witness stand at the hearing. I didn't understand the monumental amount of of people that were at the crime scene and what they were doing. I was worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation and trying to focus on everything going on in my home. I was hungover. I believe I was still intoxicated to a degree. Boone took the stand as she and her ninth attorney, James Owens, fought to have a 2-hour recorded interrogation that Boone did with detectives at the Orange County Sheriff's Office on February 25th, 2020, suppressed. Owens pointed to Boone's testimony as evidence that she was coerced by detectives because she felt she had no choice but to speak to them. A key issue regarding the recording is whether Boone was correctly read her Miranda rights, especially the ninth question that is a part of the warning. Having these rights in mind, do you wish to talk to investigators now? Orange County Sheriff's Detective Chelsea Copesell testified that she read the warning directly from her card and revealed the ninth question was never printed on the card she carries. Boone, who did not ask for an attorney at any point during the conversation, repeatedly insists to deputies that Torres' death was an accident that happened while the couple was playing a game of hide and seek. At one point in the recording, Boone tells the detectives, "I excel at everything," as she tries to explain her position. But those claims to the contrary to the defense run contrary to the defense that Boone's attorney James Owens now says he plans to present at her trial. Owens told Judge Michael Cranick that he plans to argue that Boone acted in self-defense the night of Torres' death, in part because she suffers from battered spouse syndrome. Prosecutors warned they plan to file a motion in Lamine to ask for the defense to be stricken, citing their expert's examination of Boone at the jail on Wednesday before the hearing. Boone had also requested to be allowed to have professional makeup and hairstyling for her trial. While the judge was initially inclined to allow her legal team to apply makeup after she was already in the courtroom, the Orange County Sheriff's Office stepped in and told the judge they had security concerns about the makeup, which is considered contraband at the jail. As a result, the motion was denied. On that Friday, Judge Cranick granted Boone's motion to appear at the trial without any shackles or restraints, but denied the motion to have the interrogation tape suppressed. In his order, Judge Cranick said he found several of Boone's statements regarding the timeline of events lacked credibility, and that the Miranda warning was read in compliance with both federal and Florida law. I had a feeling that was going to happen because anybody who follows true crime, anybody who's ever been arrested for anything, small or great, should know on a federal or state level, the next words you will hear once the handcuffs go on are the following. You have the right to remain silent and not answer any questions. Should you give up that right, anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford one, one will be provided for you at no cost. Having been let me go back real quick because I don't got tongue tied here. Miranda rights. Having these rights in mind, do you wish to talk to investigators now? That's the line I got tongue tied on. Anybody ever tell you that your their Miranda rights wasn't that their Miranda rights wasn't read properly? You got to be thinking, get out of here. Anyway, we'll see what happens with Sarah Boone's case as it continues to develop. Next up, we have another doctor who helped supply Matthew Perry with drugs that led to his death, and he has pled guilty to that charge. Yeah, that won't take too long. But I'll just go straight from the article. A San Diego doctor became the third person to plead guilty in the case of Matthew Perry's fatal drug overdose, as prosecutors collect cooperators in an attempt to convict two bigger targets they say are responsible for the death of the Friends star. 54-year-old Dr. Mark Chavez entered the plea Wednesday to a felony count of conspiring to distribute the surgical anesthetic ketamine in federal court in Los Angeles, after reaching a plea agreement with prosecutors in July. Chavez agreed to cooperate at the U.S. Attorney's Office pursues more serious charges against Dr. Salvador Plasencia, who prosecutors say they gave ketamine directly to Perry. The other major target in the investigation is Jasmine Sanga, an alleged dealer who prosecutors say was known as the ketamine queen of Los Angeles and supplied the doses that killed Perry last year. Chavez stood with his lawyer and answered dozens of questions from Judge Sherilyn Peace Garnett. He agreed to give up his right to trial and other rights. He listened to prosecutors as they read through every instance of him meeting with Plasencia between San Diego and Los Angeles to hand off ketamine he got using fraudulent prescriptions. In all, he admitted to supplying 22 5-milliliter vials of ketamine and 9 ketamine lozenges. Chavez cleared his throat when a prosecutor described Perry's death. "Are you pleading guilty because you did the things the prosecutor described?" Garnett asked Chavez. "Yes, Your Honor." Chavez remains free on bond until his April 2nd sentencing. He has turned over his passport and agreed to surrender his medical license, among other conditions. The judge told him that she is not bound by any agreement or recommendation and can still sentence him to the full 10 years allowed by the law, but he is likely to be sentenced to far less time because of the plea and his cooperation with prosecutors. His lawyer, Matthew Binderim, spoke only briefly to reporters outside the courthouse. "Mark entered his plea of guilty, and now that's public record," he said. "You accept responsibility, and then you set sentencing." Also working with federal prosecutors are Perry's assistant, who admitted to helping him obtain and inject ketamine, and a Perry acquaintance who admitted to acting as a drug messenger and middleman. Perry was found dead by his assistant on October 28, 2023. The medical examiner ruled that ketamine was the primary cause of death. The actor had been using the drug through his regular doctor in a legal but off-label treatment for depression that has become increasingly common. Perry had began seeking more ketamine than his doctor would give him. About a month before the actor's death, he found Plasencia, who in turn allegedly asked Chavez to obtain the drug for him. "I wonder how much this moron will play," Plasencia texted Chavez, according to court filings from prosecutors. The two met up the same day in Costa Mesa, halfway between Los Angeles and San Diego, and exchanged at least 4 vials of ketamine, the filing said. After supplying the drugs to Perry for $4,500, Plasencia allegedly asked Chavez if he could keep supplying them so they could become Perry's go-to, prosecutors said. While reading allegations in court Wednesday, prosecutors described a text message in which Plasencia asked Chavez if he approved of what they were doing. "Depends on your tolerance for risk," Chavez said. When Plasencia asked him if he was interested in starting a ketamine clinic, Chavez said he might be on board, so long as there were no shady stuff. U.S. Attorney Martin Estrada, in announcing the charges August 15th, that the doctors preyed on Perry's history of addiction in the final months of his life last year to provide him with ketamine in amounts they knew were dangerous. Perry struggled with addiction for years, dating back to his time on Friends, when he became one of the biggest stars of his generation as Chandler Bing. He starred alongside Jennifer Aniston, Courtney Cox, Lisa Kudrow, Matt LeBlanc, and David Schwimmer for 10 seasons from 1994 to 2004 on NBC's mega hit sitcom. And these doctors and the dealer helped cut his life short. Now, I gotta wonder when the next domino will fall. Who's the next one to step up and plead guilty? Stay tuned. Next up, body cam footage. Body cam footage is cops frustrated as the Laundries refuse to talk about Gabby Petito. Now I'll go with part of this and give you the video for the rest. Body camera video depicting Brian Laundrie's parents refusing to help police on the day Gabby Petito was reported missing has been released. Court TV acquired a copy of the 3-year-old footage in which Christopher and Roberta Laundrie turned police away from their Florida doorstep. Before police got involved, Gabby had been on a cross-country trip with her fiancé Brian. She'd been chronicling their journey on her Van Life YouTube channel when she disappeared. Brian returned to his parents' Florida home on September 1st, 2021 in Gabby's van, but without Gabby. Gabby's parents reported her missing on September 11, 2021. In a video from that night, Officer Ramirez with the Northport Police Department in Florida pulls up to the Laundrie home as Suffolk County, New York Detective Tracy Barry speaks to him remotely on speakerphone. Now that I got you set up that way, I am going to set this up this way. First, this is a trigger warning. I'll give you time to scroll through that before I go onward. Want to protect that mental health. And yes, viewer discretion is strongly advised. Now, there's the copyright disclaimer for that. I'm going to mute my mic, take myself out of the shot, and I will let you hear everything regarding that body cam footage, courtesy of Court TV.
Hi, Detective Barry. This is Officer Ramirez with Norfolk Police Department.
Hi, how are you?
Good, and yourself?
It's been better now that I just got some disturbing news. Did you get, I'm assuming you got to check that address?
Yes, both parents are home for Brian Laundrie. I just provided them your number.
Okay, did you see Brian? In there? Because I was told by his sister that he is home.
Well, the car is home. The camper?
The white Sprinter or whatever it is?
Yes, it's home, but they didn't give me any information. The parents.
They didn't?
No, the parents didn't want to give me any information.
I don't know what's going on, but it's pretty shady. So the white Sprinter van that I have on the thing is home?
Yeah.
His sister thought he flew home.
The actual van, The Spencer van, it's a white van, it's home.
It is.
Yeah, because I ran all the tags. The Mustang that's there comes back to the gentleman, to the father, and then there's a little white van that comes back to Gabrielle Petito.
Gabrielle.
Yeah, it's
But
parked
they're not saying she's there?
No, I can get off and stay with you on the phone so you can... They haven't called you?
Yeah, because now the sister told me she saw him and he gave her some story that he left Gabriella wherever and flew home, and now the van's suddenly home. And they won't answer any of my phone calls. I'm starting to get a little. What are they hiding? If she's there, then just tell me that she's there, and we can call this a day.
Yeah.
But I don't understand why she wouldn't reach out to her parents when I have her phone records. On average, she calls one of them every day.
Okay.
And now the son's been off, and now he's magically home with two different stories.
Oh, I see.
I'm sorry, officer. What was your name?
Ramirez. Ramirez.
Okay.
So I see. I didn't know that part, that he was home.
I only found it. So I've been trying his entire family. I called his sister, who lives in another county, Lakewood, I think. She just called me back, and she goes, he's home. And he told me he flew home, and he left Gabriella out in Wyoming or something in a hotel. So I just literally found that out. I was just going to call your dispatcher and ask for someone to call me if they hadn't been to the house yet. And I said, really? And she goes, have you called my mom? Because I saw Brian on Monday. And I said, I've been calling your mom. She hasn't called me back. And she goes, that's weird because she's home. I talked to her earlier today, and I was like, okay, what's... So she didn't have any more information than what Brian told her. She said she never saw Gabriella. She only saw Brian. So...
All right, I'm going to get off with the phone, and I'm going to ask, I just want the question, is Brian here? And see what they tell me. Hold on a second. Northport Police Department.
Yes.
How you doing, sir? I apologize for bothering you. I have the detective on the phone.
I'm not talking to anybody.
You don't want to talk to us?
No.
Okay, she's on the phone. You don't want to talk to her now?
No.
Okay, when was the last time that you saw Brian and Gabriel?
Well, Brian is here.
Brian is here?
Yeah, and that's all I'm going to say.
And that's why you're saying?
Yeah, we have an attorney. They've been calling. I don't know. That's all I want to say. I don't know why so many attorneys are aware
Okay.
they're calling. So I can give you his number.
Whose number? The attorney's number?
Yeah.
Okay, I would like that, please, so I can give it to the detective. Thank you. Thank you, I appreciate it.
Yeah.
And just to let the detective know, is Gabriel here? Or
No.
She's not here. Okay.
The fellow was here last night.
Yeah. Okay. So is this her vehicle? Her van?
It's both of them.
It's both of them? Okay.
Bye.
All right. Thank you. Appreciate it. Hello. Yeah. Yes. And it's all on my body cam.
Information I have here, her parents last physically heard from her on August 27th, and they were supposedly out in Wyoming. His sister now just told me another story about that he left her out there and flew home, and yet you're seeing the van in their driveway and they won't tell you where she is.
Yeah, and I asked him right now in front of you, who does that van belong to? And he says both of them.
Yeah, it's registered to her, and her family feels that it's hers. So, I don't know how it works out there. And her phone's been off now for 10 days, and there's been no contact with her whatsoever. So I don't know if that van's a crime scene. How did it return there? If he supposedly flew home, there's definitely some issues going on.
Okay, you have the tag on the.
Put them in touch with me.
You have the tag on the.
Maybe notify a supervisor too. I don't know how it works.
Yes, I will. I'll definitely notify a supervisor on this. The tag is Queen Frank Tom Golf 03.
Yes, that's what I have on my missing person report, because they were supposedly on this road trip in that van.
Police department. Is it Chris? Chris, this is Sergeant Selzer with the police department. Yeah. Hey, look, I hate to bother you. I know you've already said you don't want to speak or don't want to help us. I'm trying to figure out something for parents. You guys as parents, all they want is their daughter to know that she's safe. So I don't know where it all started before. I don't know what's transpired. I don't know anything about that. I'm here to know if you guys know anything. It would let the parents at ease and go from there.
Well, we don't know anything.
Okay.
That's all.
I mean, anything that you guys would be able to give them is any type of help. Last time your son saw her, anything like that.
No.
Am I able to talk to your son? The other officer said
he's not going to talk to anybody.
Okay.
We're not going to talk to anybody.
Okay. I mean, I'm gonna lay it out for you if you want. The New York detectives are a little pissed, and they want me to do a whole bunch of things that I'm trying to avoid.
Well, then you have to do what you got to do, and we're not going to. That's that.
Okay. I mean, as a parent, you wouldn't want to know where it happened with your.
I understand what you're saying, but thank you.
I mean,
no, we're not going to.
It makes it very odd, don't you think? From my point of view,
well,
Chris.
Goodbye. For now, you couldn't call our attorney and give your phone number.
I don't have your attorney, and an attorney's not going to answer at 10, 11 o'clock at night.
I'm not speaking to anybody.
Yeah, we're not comfortable
without
talking
an
to
attorney.
anybody.
So that's that.
Yeah.
Okay. So the van is only registered to her. Okay.
Well, I'm not really sure.
Well, I'm going to tell you. I'm telling you, the title on the state of Florida is it's only hers. Okay. So it's not supposed to be here.
Okay.
So I'm going to take a tow truck and get it. Is a car in the way?
That's my car. I can move it.
I mean, so you don't have any issue with us taking the van?
If that's what you're saying, you got to do. You got to do.
Yeah.
But right now, I'm not speaking to you anymore.
Yeah, without our attorney.
Okay.
I can move the car for you.
You don't find that odd that you guys really?
Good night.
Okay.
Don't knock on my door anymore.
Okay. Are you going to move the car?
I'll move it.
Okay.
Wow. That's all I can say. Wow. And it's still, at least with the way the article has gone, it still goes right back to one question. What are they hiding? You heard everything in the body cam. And right when the video ends at that point, the story took an even more tragic turn when Gabby's body was found 8 days later in Wyoming. Brian had strangled her to death, dumped her body and slinked back to Florida in Gabby's van. On October 20th, 2021, he was found dead in a nature preserve near his parents' home. He shot himself in the head and left behind a notebook wherein he confessed to Gabby's murder. So the only question that's still left is, why would the laundries not help police figure out what was going on between Brian and Gabby? Okay. Moving onward, we have a brand new case coming up. The home renovation murder trial. State of Florida versus Corey Binderim. Corey Binderim is facing the death penalty if convicted in the murder of Susan Malden, who is his home renovation client. Yes. Yeah. It's already underway. A Florida contractor accused of killing a client is facing the death penalty if he's convicted at trial. 49-year-old Corey Binderim is facing multiple charges, including premeditated murder in the October 2019 death of 65-year-old Susan Malden. Investigators allege Binderim killed Malden because she was going to sue him over a botched bathroom remodel. Court documents state Malden paid Binderim approximately $12,000 for the project. Binderim demolished the bathroom, but failed to finish the job and failed to show for work on multiple occasions over the next several months. Before her disappearance, Malden told multiple people that she was going to tell Binderim he must refund her money or she would sue. Binderim was scheduled to come to Malden's home on October 23rd, but he didn't show. Malden was reported missing by a friend on October 25th, who alerted investigators to the issues with Binderim, and authorities said blood was found in Malden's living room and kitchen. According to the affidavit, investigators were able to track Binderim's movements on October 24th. Video surveillance allegedly showed him at a Home Depot purchasing bags of concrete and heavy-duty demo bags. Afterwards, he called Malden twice and drove to her home for a short period of time. After leaving Malden's residence, investigators tracked his vehicle to his home, then to a landfill where he dumped approximately 300 pounds in the construction area, according to the affidavit. That waste was ultimately transferred to another landfill in Folkestone, Georgia, where authorities conducted a search in January 2020. Over 2 days, search teams recovered human remains that were confirmed to be Malden. On October 3rd, we had opening statements. Phyllis and Daniel Yates, who reported Susan Malden missing, testified about Malden's frustrations with Binderim. The trial will continue on Monday. And I will keep abreast of this case, and I will be sure to report on a verdict watch, and if necessary, a sentencing. Speaking of sentencing, we have another sentencing to go through this evening. The brother and sister murder trial. A brother and sister was convicted of killing their disabled mother, and now they're about to be sentenced on charges of first-degree murder and aggravated neglect of a vulnerable adult. So, here we go again. The disclaimer is up. I'm gonna mute my mic, take myself out of the shot, and we're going directly into the courtroom.
You have to drink it.
Vulnerable adult, and in count 3, they were each found guilty of aggravated neglect of an elderly or vulnerable adult. The victim being their mother with whom they lived here in Johnson City, Washington County, Tennessee, and were charged with being her caregivers. The jury imposed a fine in counts 1 and 2 of $12,500 each. Count 3, I believe, was a Class C felony, so not that it makes that much difference, but I'll amend the fine.
Thank you, Judge.
The fine imposed in count 1 was $25,000. The only sentence that is available, the state did not seek life without parole or the death penalty in this case. So the sentence for first-degree murder during the commission of a felony, which would have been the aggravated neglect of a vulnerable adult, is life in prison, and that is a 51-year sentence. A little bit more than that, probably 54 years at this point. The sentence range for count 2 for each defendant would be 8 to 12 years, and for count 3 would be 3 to 6 years, which there's no dispute that from the state that those counts would merge as the elements are similar. And under 4035-115, the sentencing guidelines on multiple convictions, consecutive versus concurrent sentencing, the state does not argue that consecutive sentencing apply for these particular counts 2 and 3 that were obviously merged. The court therefore will run the sentence to be imposed in counts 2 and 3 concurrent with the life sentence. Both defendants are, based on their dates of birth, are in their late to mid-40s. I think Miss Murray is about 49 years old. Mr. Murray is about 44, 45 years old. So this is truly absent action on appeal would bring this case back as a life sentence for these people. And it's an extremely tragic case. The court has reviewed the notes I took during the trial, and I will note that since they had no prior record, that was stipulated to, and the only sentence that they're going to count 1 would be a life sentence. A sentencing report was not prepared. There's no enhancement in terms of in the range, no prior convictions to review. The court has reviewed the notes that I took during the sentencing hearing, or during the trial, excuse me. And this is an extremely troubling case. And I think the state is correct in terms of the determination was made, albeit by the person that's in the empty chair, Mr. Tony Murray, the husband of the victim, Sheila Murray, and the father of the 2 defendants. He's getting a lot of the blame, and of course he passed away after Ms. Murray died and before the parties were indicted. He's on it, so he's getting a lot of the blame for the decision making on this. And I do think it was apparent that the decision was made to keep Sheila Murray at home with private care from the family, as opposed to placing her in either a rehabilitation facility or a nursing home, some type of skilled care, due to the possible ramifications of a lien being placed on the home. The testimony did support that that was Mr. Murray's decision, and he made the decision to take her home. However, while he was working, Karen and Michael Murray did take on the responsibility and engage in substantial caretaking activities for their mother. Those caretaking duties began to either be overwhelming They began to be too much. They imposed too much into their own lives. And that would have been understandable. And at that point, a decision had to be made that it was beyond their capacity, beyond their ability. At that point, the decision should have been made to let authorities know she's in bad shape, we can't take care of her, it's beyond our ability. She's going to have to be cared for by a professional medical team, nursing home, a facility that's designed for that type of skilled care. That was not done. And Sheila Murray's condition deteriorated under the care of her son and daughter and the father, to the point that when EMS came to find her at the home, she was in such a state that a seasoned, trained emergency room physician was, years after Sheila Murray's treatment and death, moved to sobbing tears when she recalled her injuries and the condition she was brought in. The pictures are nothing less than horrific of your mother. And there is absolutely no way, it would be physically impossible for anyone who entered even the home, much less the room of Mrs. Murray, to not realize the neglect that she sustained. Her back was basically almost rotted out. The bed sore on her back was so large it almost encompassed her small frame. Her breast had not been moved from underneath her arm in so long that it had nearly rotted off. Her ankle was broken, and to the extent that the bone was protruding through the side of her foot, and had been in that situation so long that it was necrotic, it was black, it was deteriorated, and had clearly had a lengthy period of neglect for that type of event. The EMS officers, John Shelton and Joshua Jenkins, said that they had both had hundreds of calls that involved very graphic, sad, neglectful, horrible situations involving children of all ages up to elderly adults. And this was, to quote Mr. Shelton, one of the top 5 worst calls in his career, spanning hundreds of calls. Everyone involved in the treatment of Ms. Murray, who had been in the medical profession not just days or weeks, but years, recalled specifically how graphic, how painful, how difficult it was to see her in the circumstances in which she had been left by her children and her husband. Dr. Lawson, who first cared for her at the medical center, described it as horrific. The conditions didn't occur overnight, and that she had a very clear memory of what Ms. Murray appeared like in the emergency room. She was covered in fecal matter, she smelled of urine. Her room was described as having no same smell by the EMS personnel who transported her from the home to the hospital. And again, these bodily fluids and bodily substances had been there a long time, to the extent that when she was attempted to be cleaned, her skin kept. Again, this did not happen overnight. Dr. Cook, the medical examiner, the forensic pathologist, who described her wounds as, again, not being able to happen in just a very short period of time, said the sores could have been prevented. The necrotic tissue could have been treated. Her wounds were something that could have been taken care of had she received the appropriate medical care. This is a horrible case for people who should never be in courtroom. They don't have a criminal record. The defense counsel is right. I don't think you're thieves or thugs or probably anyone that would likely hurt someone in the future. However, you let your mother deteriorate to such a condition that it caused her death, and that condition had to result in terrible pain, indescribable suffering, and humiliation of a medieval type that no human should have to endure. Basically, she was nearly thrown in a dungeon and left to rot, and that's exactly what. All that had to happen was a phone call being made for somebody to come. And rather than do that, she was left in that dungeon, in that cell, and the only crime she committed was having 2 children and didn't care enough about her to take care of her for him. And she was not an elderly lady. She had had a horrible stroke, a debilitating stroke that left her as vulnerable as a newborn. And that was bartered for financial reasons to keep the house. It's unforgivable. And it can't be fixed. You may not be horrible people, but the way you treated your mother was horrible. And the jury found exactly that. Having said that, the state is right. A lot of people are being charged these days with neglecting elderly adults. We have an aging population, especially in this region, and we're seeing more and more of these cases. Deterrence might be a factor, but I think people just decide they're not going to do it. They're not going to take care of these folks. It's just too much, too hard. But whether it be for reasons similar to what Karen and Michael Murray did, along with the decision making of their father to, well, we're just going to keep the house and we'll do what we can. We're going to live on the elder person's Social Security or retirement, and we'll just let them lay there. However it be, these people are completely vulnerable. And I wish I thought this crime would be deterred, but I don't think deterrence is the factor that would apply in this case. So in terms of the factors that would apply for enhancement in range, the state argued factor 5, the defendant treated or allowed victims to be treated with exceptional cruelty during the commission of the offense. The court finds that really brushes very closely to the elements of the offense of counts 2 and or 3 on the aggravated neglect of a vulnerable adult with injury or harm. While any one of her injuries that the court has detailed could have been considered sufficient for those particular crimes, the court has no way of knowing what ones or if the overall injuries were considered by the jury as an element of those offenses. So, out of abundance of caution, the court would hold hands and range on those, and that would be the only factor that would apply. The mitigation factors, the court does not find that any of those necessarily applied. Both defendants were equally responsible for the care of their mother, even though Karen Murray may have handled more sensitive areas of her body, both of them being females. Still, there was plenty of wounds on her body that were not in private or intimate areas. that were clearly visible and seen. The court, again, finds that consecutive sentencing would not apply. So the court in count 1 sentences Karen Murray as defendant A in case number 47002A to life in prison for the first-degree murder of her mother. And we will serve that sentence in custody of the Department of Corrections until that sentence expires. In count 2, the court will impose the sentence of 8 years concurrent with the life sentence. And in count 3, 3 years, which will merge with count 2. The court.
I'm sorry. With regard to the fines, I believe we thought the jury hadn't set a fine. So
it's on the judgment form. It's on the verdict form.
It was, but we didn't have the verdict form because there was a question about whether they had to set a fine, and we thought they hadn't, and the defense agreed to waive that. But then we actually got the judgment forms that it actually had
yeah, I do recall that. That's fine. It's not going to make any difference in terms of collecting that type of fine. They'll earn a very small per hour wage with the state for any work that might be performed in penitentiary settings. So the court will not impose a fine. The jury on the verdict form did include a fine, but I think when they announced their verdict, they did say they didn't say. The cause for tax to each defendant. And case number 47002B, as to Mr. Michael Murray, the court does impose a life sentence based on the verdict of finding the jury. That is the only possible sentence. In count 2, Mr. Murray is sentenced to an 8-year term concurrent with the life sentence. And in count 3, which will merge with count 2, a 3-year sentence is imposed. Extremely tragic case. Ms. Sheila Murray should have been cared for in a setting with medical professionals, and Mr. and Ms. Murray should be living their lives. As Karen Murray said, they have their own lives to live. Regrettably, both of you will be living the rest of your lives absent any action on appeal in the custody of the Department of Corrections. And you are therefore sentenced, each of you, to a life sentence. Anything else?
I don't think I marked it.
What?
I don't think I marked it on the judgment, but I think I'm supposed to mark the part where the clerk's supposed to send it to the Department of Health on counts 2 and 3. So it would go for the registry. I know it's a moot point, but they would need to send that into the Department of
they would be on that elder abuse registry, but again, absent this being overturned on appeal convictions regarding, I don't see that, but I'll note that on the judgment. We do need a motion for next trial date.
With that, because I've got a perfunctory motion for new trials to go ahead and file today.
Speaking on those, okay. All right. Mr. Berg, consummately prepared. All right, you have asked for a transcript. Mr. Dawson, if you'll get me a transcript and file the motion for new trial within 30 days from today on behalf of Mr. Michael Murray. I'll call this with the clerk. Get that to Mr. Slot. I can't remember who covered this.
I did.
You did? All right. Let me rotate forward. All right. The motion for new trial will go ahead and set. Again, we rule permission to amend the motion for new trial once transcript is received. The motion should be filed not later than November 1st, because November 3rd is a Sunday. And I will order the transcript prepared, and a copy, just a duplicate, can be made for Mr. Donaldson based on Mr. Byrd's request for a transcript. The motion for new trial, again, will be given liberal permission to amend the motion for new trial. How far out would council prefer to go to hear the motion for new trial? We want a status date maybe in January to see where we are. I know that on trials, some of which both of you have been involved in, the transcripts are still being prepared.
Yeah.
So I wouldn't expect this transcript to be ready before the first of the year.
We decided to in January or February.
We have a miscellaneous day on January 31st. Is that too close?
No, well, my only issue, Judge, I've got a jury trial scheduled in federal court, which should be done by then. It's that week. It starts the 27th, and it's not a factually complicated case. I don't imagine it will go to the 31st. And then we can send it to that, and if there's a problem, we could reschedule us.
I've got February 20th.
Can we do February 20th, because just in case DeAndre will go over, I don't expect it to, but we said that
and assuming that Mr. and Miss Murray will be transported to a state prison between now and then, I will order them not to be transported since that's a status date. Again, I would expect that transcripts will take at least the end of the year, if not more. And Ms. Shalott, who does most of the typing, our court reporter, she's had surgery, so she may be a little bit more behind.
Because I believe we got everything we needed to hear as far as that sentencing goes. But to recap, both Karen and Michael Murray were found guilty of first-degree murder and aggravated neglect of a vulnerable adult in the death of their mother, 68-year-old Sheila Murray. As such, both have been sentenced to life in prison. I guess the family that murders together goes to prison together. For aggravated neglect of a vulnerable adult, the siblings were each sentenced to an additional 8 years concurrent with the life sentences. The judge also gave them 3 more years to be merged with count 2. So regardless, they will spend the rest of their lives behind bars. No parole is even considered, and I will be reading their last rites at the end of this edition of Bethea'S Byte Reloaded. Next up, Brendan Banfield, charged in the deaths of Christine Banfield and Joseph Ryan. Now there are more details that were revealed in court regarding him and the au pair. Expert bloodstain pattern and forensic analysis helped investigators pursue charges against a Virginia husband accused of killing his wife and another man at the married couple's Fairfax County home, prosecutors said during a bond hearing. Last month, a grand jury indicted Brendan Banfield on charges of aggravated murder in the February 2023 killings of Christine Banfield and Joseph Ryan. At the time of his arrest, which occurred more than a year after the incident, Fairfax County Commonwealth's attorney Stephen Discano said new information found in officials' investigation was instrumental in securing today's indictment. but he declined to elaborate further. During last week's bond hearing, Deputy Commonwealth's Attorney Eric Klingen said police received in August 2 definitive reports from forensic investigators who spent more than a year reviewing evidence. Klingen said the reports were foundational in supporting the prosecutor's theory that Ryan and Christine Banfield's bodies were moved and repositioned after they were fatally wounded. Klingen also said Ryan's arms were moved and smeared with the wife's blood. Brendan Banfield's attorney John F. Carroll argued in court that Klingen's narrative of what happened was not evidence of the cut of the husband killing his wife. It just doesn't add up, Judge, he said. At the end of the hearing, Fairfax Circuit Court Judge Penny S. Askerit denied Banfield bail, requiring the defendant to remain in the county jail until his trial, which is scheduled for February. The blood splatter evidence is one piece of official sprawling investigation into Banfield and Juliana Perez Magalhaes, the family's au pair, who was also charged with second-degree murder in Ryan's killing. Magalhaes was arrested last October and will face trial this November. Authorities have said the killings were part of a larger scheme between Magalhaes and Brendan Banfield, whom officials alleged had begun a romantic relationship in August of 2022. In the 6 months before the killings, Magalhaes and Banfield went on a trip to New York City together, took romantic pictures together, Klingen said. The prosecutor also said the other women had informed detectives that Banfield participated in multiple extramarital affairs during his marriage. Multiple credible women confirmed this fact, including one in particular who told them that during the course of her affair with this defendant a few years ago, he would constantly promise to leave his wife, Klingen said. Eventually, he told her it would be so much easier for us if she was not around, end quote. On the day of the killings, authorities have said Magalhaes called 911 at least 2 times within minutes, but authorities said she ended the calls before speaking with first responders. More than 10 minutes later, authorities have said in court Magalhaes called 911 a final time and reported the emergency. Brendan Banfield then spoke into the phone and said he had shot a man because that man stabbed his wife. Authorities soon arrived at the Banfield's home in Herndon, Virginia, and found that Ryan had been fatally shot and Christine Banfield was suffering from stab wounds. She was taken to the hospital where she died. Klingen said following the killings, Magalhaes told authorities that she and Brendan Banfield left the house early that morning, leaving Christine Banfield home alone. Magalhaes said she and Brendan Banfield returned later that morning after the au pair saw Ryan, who she alleged was trespassing, enter the home. When Magalhaes and Brendan Banfield went inside, the two found Ryan holding a knife to Christine Banfield's throat. Magalhaes said to detectives she alleged Ryan stabbed Christine Banfield and that Brendan Banfield then shot Ryan. Magalhaes also told authorities that she shot Ryan once with a second firearm. During the court proceedings for Magalhaes, prosecutors questioned her account of events, arguing that Ryan was not known to be violent. In court last week, Klingen said Ryan came to the house after matching with an online profile portrayed as Christine Banfield on a website for people interested in sexual fetishes. Authorities alleged Ryan came to the house after messaging the profile's user on Telegram and scheduling a sexual rendezvous. Ryan told a friend Christine's marriage was not entirely monogamous, adding that Brendan Banfield was aware of the extramarital activity of his wife. In the 11 months between Magalhaes' arrest and the indictment of Banfield, authorities said they monitored their phone conversations at the Fairfax County Jail. A few weeks ago, Klingen said Magalhaes and Banfield had a brief phone call in which he said, "I hope you are not just staying with me because you are afraid I'm going to turn against you." And in the words of Mary Poppins, I believe, curiouser and curiouser. No, I take that back. It wasn't Mary Poppins. It was Alice in Wonderland. Either way, I'm gonna have to keep an eye on this case and come back with more details as it comes up. Now, a wife is being accused of murdering a missing Utah National Guardsman. Police have arrested the wife of a missing guardsman from the Salt Lake area, and they say she is being charged with murdering him. 51-year-old Matthew Johnson was reported missing on September 23rd after he didn't show up to work at his Utah National Guard base. Police asked for the public's health and said his disappearance appeared suspicious. His truck was found a few blocks from his home in Cottonwood Heights. Police determined he was last seen on September 20th, and witnesses told investigators that Johnson and his wife had an argument sometime between September 20th and 21st. Cottonwood Heights police also said officers had previously been called to the family's home, and they knew the couple was considering a divorce. They have 3 kids together. Let me quickly take you to video coverage, courtesy of our friends at Court TV.
Time to reveal something else you need to know tonight. Let's look at the big board. Husband missing, wife accused of murder. This is a case you need to know about. Wow. You're talking about the victim here. Here he is, Matthew Johnson, a member of the National Guard. But even more importantly, a husband and a father. 3 young children. The woman next to him, that's the one accused of his murder. Let me read from the probable cause affidavit. Jennifer Gledhill, that's her name. According to a confidential informant, openly admitted to killing Johnson by shooting him in the head while he slept. Johnson was shot while on the mattress inside the master bedroom of their home in the beautiful Cottonwood Heights area of Utah, $1 million home. Jennifer also told the informant that she had removed the body and had relocated his remains to a shallow grave at an undisclosed location. Could she do it by herself? Since September 21st, Matthew has had no contact with anyone, including his children. He is missing. We will keep an eye on this story for you folks.
And as you saw on the probable cause affidavit, Jennifer Gledhill, the accused in this case, has been charged with not only murder, but she's also been charged with obstruction of justice. More details as they come in on that case. Now, here's a story that everyone's been talking about. The Menendez brothers. The Los Angeles District Attorney is announcing that he's investigating new evidence. Could this be the thing that sets these 2 free? Could it be something that'll bring a possible new trial? The article says that Lyle and Eric Menendez are one step closer to freedom. Los Angeles District Attorney George Gascon announced at a press conference on Thursday that he's looking into new evidence that has come to light about the Menendez brothers, who were convicted of their parents' 1989 murders and sentenced to life in prison. Gasson said his office is reviewing new evidence and determining whether it merits reconsideration of resentencing the Menendez brothers, and the hearing will be scheduled on November 29. A habeas petition can be filed when a convicted felon requests a review of new evidence or when prosecutors can review whether a convict has been rehabilitated. Lyle and Eric Menendez want their case re-examined under both circumstances. The brothers filed this petition in May of 2023. We're going to take this to Court TV via YouTube, and covering this story will be Michael Ayala with a press conference. So here we go.
Welcome back to Court TV Live. I'm Michael Ayala. We are continuing to follow breaking news from Los Angeles. The Los Angeles County District Attorney George Gascon is holding a news conference on the Menendez brothers. The DA is giving an update on the convictions of Eric and Lyle Menendez. The Menendez brothers have spent nearly 35 years in prison for killing their parents, Kitty and Jose Menendez. I want to take you there now. Now, again, we've been taking this feed in. There are a number of hits and imperfections in it. We apologize for that. The feed is not ours. We can only take in what is sent out. So let's take a look.
We've also got evidence that was provided by the defense, by his lawyer, that one of the members of the Menudo band alleged that he was molested by the father. None of this information has been confirmed. We are not, at this point, ready to say that we either believe or do not believe that information. But we're here to tell you that we have a moral and an ethical obligation to review what is being presented to us and make a determination based on the resentencing side, whether they deserve to be resentenced, even though they were clearly the murderers, because they have been in prison for 35 years and they have paid back their dues to society, or whether habeas is appropriate if there was evidence that was not presented to the court at that time, and had that evidence been presented, perhaps a jury would have come to a different conclusion. I don't think there is any question in this case that the boys, or the young men, one was 19, the other was 21 at the time, that they murdered their parents. I think that's factual, it's been established. I think the questions that are presented to us, there's two simple questions. One possibility, what is being alleged by his lawyers, not by us, that there was evidence that had that evidence been presented to the jury, the outcome of this case would have been different. And second, under California law, a path to resentencing where a prosecutor can evaluate whether someone has been rehabilitated, and if so, ask the court to determine whether the person should be resentenced. If they get resentenced, there are multiple things that could happen. They could walk out based on what the court decides, or they could have the sentence given a different shape, and perhaps they will stay on, but for a longer period, lesser period of time, or they can have a new trial. Right. Those are all options, and we will evaluate all of it. We have a hearing coming up on November 29th, and until we get there, we're not sure yet which direction this will go. Are there any questions? Oh, by the way, one of the things that I want to add too is I think it's important that you contextualize what resentencing means. Since I've been in office, we have resentenced over 300 people. Of those, only 4 have reoffended, which is probably one of the lowest recidivism rate of any group that I'm aware of. If you do the math, and I'm here standing because if I was better at math, I would be teaching math or doing something else. It's a very low rate. In fact, if our recidivism rate for all the crimes that we face were to be that low, we would be the safest society in the world. We're not. So just so you understand also, this concept of resentencing is a concept that we have used successfully many times and will continue to do more successfully. Any questions?
Other than the November 29th hearing.
Excuse me, I got a question. I'll get to all of you. Yes.
Given the cultural shift in how we view sexual assault, do you think that this case would have been handled differently if it was tried today?
Look, because I don't know yet the validity of all the evidence that was presented as opposed to the evidence that was not presented, I'm not here to make judgment of that, but there is no question that today would have been a greater level of sensitivity to the way the case was looked at.
You've had this evidence for over a year now. Why speak out today and now?
Well, there's a combination.
All right. So we're going to step away. It's just becoming a little bit difficult to follow. But all right. They want us to stay in. Let's stay in.
We did this very, very carefully. Often we go back and not only do we go through all the... Yes, sir.
Other than the November 29th hearing, what's...
I'm sorry, guys, but I couldn't keep that. I couldn't keep that footage going. I'm just gonna go ahead and take it straight from the article. From where I left off. The new evidence includes a letter Eric Menendez sent his cousin Andy Cano 8 months before the murders that his attorneys say prove he was sexually abused by his father. The defense also alleged sexual assault allegations by ex-Menudo member Roy Rosello, who revealed details of the alleged sexual assault and sexual abuse by Menendez in a Peacock document series, Menendez and Menudo, Boys Betrayed. They argued that if this evidence had been presented to a jury the first time around, the outcome would not have been the same. This comes on the heels of the success of Netflix's Monsters, the Lyle and Eric Menendez story, which sparked renewed interest in the trial. Jose and Kitty Menendez were gunned down in their Beverly Hills home on August 20th, 1989. Their brutal deaths sent shockwaves around the world. Lyle and Eric's first trial ended in a hung jury, but they were found guilty the second time they were tried. To this day, California versus Menendez remains one of the most high-profile cases in Los Angeles. Lyle and Eric, who were 21 and 18 years old at the time of the killings, contend that they killed their parents after years of sexual assault. Prosecutors, however, argued that they were motivated by money. Jose was a record company executive worth millions. If a retrial or resentence were to be granted, one possibility is if their convictions were to be downgraded from murder to manslaughter. Lyle and Eric Menendez, who are now 56 and 53, could potentially be released due to time served. The brothers have been locked up for over 35 years. The brothers have repeatedly appealed their convictions over the decades, but have not yet succeeded. Aside from the Netflix special, the case has stirred a movement among people who weren't even born yet when the murders occurred, demanding Lyle and Eric Menendez be set free. They say the system did wrong by the brothers. The group refers to itself as Menendez Defenders and Guardians, and they've been vocal on TikTok and other social media. Surviving relatives of the Menendez brothers have publicly supported their release. Me personally, I won't say that I'm supporting their release or not, but I will say that I am supporting investigating brand new evidence. And if it can set him free, then so be it. If not, then the Menendez brothers are right where they belong. That's all I'm going to say about that until something comes up that says I'm wrong. All right, this is one that Amy follows. I'm following, and I know a number of you are following as well, because of all the other cases like this happening. Okay, Garth Brooks accused of rape in a lawsuit from hair and makeup artist. A woman who says she worked as a hair and makeup stylist for Garth Brooks alleged in a lawsuit filed Thursday that he raped her in a Los Angeles hotel in 2019. The woman does not use her name and goes by Jane Roe in a lawsuit filed in Los Angeles Superior Court. An email seeking comment from Brooks' publicist and attorney were not immediately answered. A woman says in the lawsuit she had worked for Brooks' wife, country singer Trisha Yearwood, since 1999 and had started working for Brooks in 2017. She said the assault occurred when she traveled from Nashville to Los Angeles with Brooks, who was performing with soul singer Sam Moore at a Grammy Awards tribute to Moore in 2019. Let me do a little digging real quick. Just a minute, guys. I'm doing a little digging real quick. Oh, okay. Yeah, okay. Now I know who they're referring to. Okay. Moving onward. Brooks normally traveled with an entourage, but the two were alone on his private jet, and he booked just one hotel suite for both of them, the lawsuit says. The woman alleges that in the suite he appeared naked in the doorway to the bedroom and raped her. The suit says that he then proceeded as though nothing had happened and expected her to do his hair and makeup immediately after. She alleges that earlier in 2019, when she was at Brooks' home, he had appeared naked in front of her, grabbed her hands, and put them on his genitals. The lawsuit says that Brooks filed his own preemptive lawsuit in federal court in Mississippi last month, in which both he and the woman are anonymous. In court filings in that case, the plaintiff, going by John Doe, says the allegations are wholly untrue, and he first learned of them in July when she threatened to publicly sue him unless he gave her millions of dollars. He asked the judge to stop the woman from intentional infliction of emotional distress, defamation, and false light invasion of privacy. The woman's suit also says Brooks exposed himself to her many other times and talked about sexual fantasies with her and sent her explicit text messages. She said she was forced to keep working for Brooks because of financial hardship, which he knew about and took advantage of. An email to the woman's attorney, whether she had reported her allegations to police, were not immediately answered. The 62-year-old Oklahoma-born Brooks was the biggest country star in country music of the 1990s, with hits including Friends in Low Places and The Thunder Rolls. He brought arena rock theatrics to his concerts and a pop music sensibility to his recordings. He had huge success that went beyond typical country audiences. He married fellow country star Trisha Yearwood in 2005. There was no immediate response to a message to a Yearwood representative seeking comment on the lawsuit. We're going to take you right now to the video that accompanies this article. Let's go to Court TV, Julie Grant, and what she and her experts think of this.
Now for what's trending in true crime, a new lawsuit accuses country music superstar Garth Brooks of sexual assault and battery. The plaintiff, who calls herself Jane Roe, says she worked for Brooks as a hairstylist and makeup artist and traveled with him on work trips. Brooks is famous for songs like Friends in Low Places.
I got friends in low places where the whiskey drowns and the fear chases blue.
In the lawsuit, Jane Roe alleges that the incidents occurred in 2019 and claims that she was once raped by Brooks during a work trip. Now, in addition to sex assault and battery, the suit accuses Brooks of repeatedly exposing himself, talking about sex, and sending sexually explicit text messages. In a statement to CNN, Brooks said, quote, "For the last 2 months, I have been hassled to no end with threats, lies, and tragic tales of what my future would be if I did not write a check for many millions of dollars. Hush money, no matter how much or how little, is still hush money. In my mind, that means I am admitting to behavior I am incapable of. Ugly acts no human should ever do to another." Now, the year of these incidents is 2019, these incidents that are in question. And that's what's been identified by this plaintiff. And in California, there's a 10-year statute of limitations for rape. Okay, so this case could be in a prosecutor's office if they accepted it, if they vetted it and felt there was a reason to go forward. So we're wondering this morning, why a lawsuit and why not go to police? Let's bring in our guest. Joining me this morning, retired FBI special agent and the host of Break the Case, Jennifer Coffindeffer, and criminal defense attorney and former prosecutor, David Bruno. Good morning to you both. So much to unpack here. And so let's begin, if we can, with the idea that this could still be prosecuted if it has merit. And when I saw that date, I'm like, wait a minute. This is post Me Too. This is post Time's Up. This could be in the DA's office right now if it's reported. Agent Coffindeffer, could we start there with you? Your thoughts on that, please?
Well, I agree with you, Julie. It doesn't make a lot of sense to go straight to a civil suit and not even go to police, at least that we're aware of. And I have to tell you, some of the details in this civil suit also don't make sense. It's very explicit, being held upside down by one's feet as they were sexually assaulted, in midair. It's very strange. In addition, the time span. But I'll tell you what, there are supposed audio and text messages that support her position. I'll be very interested to see and hear those.
Right, Agent Coffindeffer, and thank you for that. In this suit, and this is, it's not a long suit. It is explicitly detailed, and when you really read it, I'm glad you pointed that out. So on pages 13 and 14 of it, it details this alleged rape that this woman is claiming happened, and saying that she goes on a work trip with him and that he only rents one hotel room for the both of them, and she's in there with him and this rape happens, where, as you said, Agent Coffindeffer, she claims that he had held her upside down by her ankles and penetrated her. That is just one of the allegations. It's a Vehement 74, if anybody wants to look that up. And she goes on to say that a few months later, there was another incident. And I guess I'm scratching my head this morning because if this was a violent rape and such conduct is being alleged, I don't know why this hasn't been brought to police. David Bruno, you're an attorney. You've been on both sides of the courtroom. Why do you think they're going the lawsuit route here?
Well, look, this is a long-standing employee. She was there for 20 years. And the first questions that I would have is, at the time of the incident, was police contacted? Now, I would bet that the answer is going to be no, because if so, I mean, police would have absolutely furthered an investigation to identify whether or not they could prove the case beyond a reasonable doubt. Let's not forget, civil, preponderance of the evidence, criminal, proof beyond a reasonable doubt. And as prosecutors, when those types of cases and investigations come in, they have the resources to do what they do. DNA would be something, search warrants on the room itself, trying to find forensic evidence to corroborate these allegations, because these are very serious allegations, obviously, allegations that would land Garth Brooks in prison. So with that being said, if that didn't happen, then the prosecutors handicapped. They have problems because without the forensics, it's a he said, she said, and if there's no corroborating evidence, then it goes to the weight of the evidence, and that's why prosecutors may not have brought criminal charges.
David, appreciate that. And I read the lawsuit multiple times, and Ian Veerman's 98, 99, and 100. It makes it sound, perhaps, like this could have been a consensual affair and a regrettable one. And so, to be fair here to Garth Brooks, we want to balance this out. Okay, the allegations are that he raped her in this hotel room repeatedly, sexually assaulted her, made lewd comments, all of that. But then on the other side, before the suit was filed, we know that there was an anonymous celebrity, now disclosed to be Garth Brooks, who tried to block her legally from going public with these allegations, saying that they're false. So in a statement, Brooks said, quote, "We filed this suit against this person nearly a month ago to speak out against extortion and defamation of character. And we filed it anonymously for the sake of families on both sides." Now, this woman's attorney told CNN that Brooks' efforts to silence our client through the filing of a preemptive complaint in Mississippi was nothing other than an act of desperation and attempted intimidation. So I want to be really clear here. Before this lawsuit by this plaintiff was filed, her legal team called up Garth Brooks' legal team and said, by the way, here's a copy of this. We're going public with this if you don't settle it. So they were made aware that this was going to come out and this was going to be made public. So now let's talk about, why did Garth Brooks then go ahead and file this civil suit? He could have settled if he wanted to. So bearing that in mind, he could have settled. He has the money to make this go away, but he didn't. He didn't. Why did he do that? Let's bring back in Jennifer Coffindeffer and David Bruno. Agent Coffindeffer, let me go back to you on this one. Why do you think that he went the legal route, trying to block it, rather than settling this quietly, which we know he had the means to do?
Well, when I see something like this, I think it's because he truly believes that he is not responsible for raping or sexually assaulting this woman. Remember, there is motive on her part. Supposedly, she was seeking to be salaried. She was seeking a raise. She was seeking medical benefits. And that wasn't going to be allowed by Garth Brooks. He had just employed her as a contracted makeup artist. So there is motivation here. Obviously, he also has very deep pockets. And Julie, I think he wanted to get ahead of this. I think you also bring up a good point. Could this have been a consensual situation? I think definitely he feels like he was being extorted.
Jen, I appreciate that. David Bruno, let me go to you here, please. Do you think that was the smart legal move for him? You know, because he's saying he didn't do this. So bearing that in mind, if you're his lawyer and he's saying, look, I didn't do this, do you think he did the right thing by taking that preemptive strike with the court to try to stop this from becoming a civil suit?
Garth Brooks is the only person that could answer that question. It really depends on the truth of these allegations, because look, in his statements, we don't have to go too far to get the answer as to why. He said hush money is hush money, no matter how big or small. And that goes against his values and so he has taken a stance. Now it's a public stance. Now it's going to be brought out. Look at this. We're talking about this now. This is a public filing. He has his extortion claim filed. She has her sexual assault claim filed. And now it's out there. So every litigant, every person that has to make that decision has to look deep into whether or not, number one, is there an admission that was required for that pretrial settlement? What entailed the money, the financials to get out of this? And he had to make that decision in his heart, what was best. And look at what he has done. He has brought this out. And if it was a consensual act, well, then that's going to be a public story. And that's going to be just as bad, if not, for his public relations.
David, it's a fair question here. In really, that's the question that I guess is going to go through the court system. Was this in fact a rape, or was this a consensual sexual encounter coupled with regret and a plan to try to seek money? We will leave it there for now. Great analysis from you both, and you're sticking around. Jen Coffindaffer, David Bruno on the show. Coming up next.
Special thanks to David Bruno and Jennifer Coffindaffer. My take on this whole situation is, first off, I gotta go back to that original question. If what this person is saying is true, then why a lawsuit, and why not go to police? Number one, when it happened. And number two, Garth Brooks hit a major point when he said in his statement, hush money, no matter how small or great, is still hush money. He's gonna defend himself against these allegations, and I don't blame him. All right, next up we have another new case coming up: the Burn Pile murder trial, State of Georgia versus Melody Walker Farris. A Georgia woman will stand trial this coming week on charges she killed her husband and burned his remains on their property. Melody Walker Farris is charged with malice murder, felony murder, aggravated assault, concealing the death of another, and making a false statement in the death of her husband, Gary Farris, who was a prominent Atlanta area attorney. The couple, who were married for 38 years, lived on a working farm in Alpharetta that spanned approximately 10 acres. They lived in the main house together, while one of their 4 adult children lived in an apartment above the barn. On July 5, 2018, deputies with the Cherokee County Sheriff's Office were called to the property for a report of human remains in a fire. Detectives initially believed Gary could have suffered a medical issue and fallen into the fire, but quickly began investigating the case as a homicide after a bullet was found lodged into one of Gary's rib bones. The bullet, a .38 caliber, did not match any weapon found during the searches of the property. Investigators say the Farris marriage was rocky, and Court TV reviewed documents showing that Gary filed for divorce in February of 2010. The petition was dismissed that August. Melody initially denied having any extramarital affairs when asked by investigators, and then later claimed her affair with Roy Rusty Barton ended a year before her husband's death. But investigators determined that was a lie, and later arrested her in Tacoma, Tennessee, where she had been spending time with Barton. Prosecutors say at the time of the murder, the couple had been arguing about finances, specifically Gary's refusal to give Melody money, but instead giving it to their adult children. And that case, that trial, I believe, will begin tomorrow. I'll be watching out for it. We have a mixed verdict in the Memphis officers convicted in the fatal beating of Tyre Nichols. Three former Memphis police officers were convicted Thursday in the 2023 fatal beating of Tyre Nichols, but were acquitted of the harshest charges they faced for a death that sparked national protests and calls for broad changes in policing. Jurors deliberated for about 6 hours before coming back with mixed verdicts for Tadarius Bean, Demetrius Haley, and Justin Smith. All were convicted of witness tampering related to the cover-up of the beating. But Bean and Smith were acquitted of civil rights charges. Haley was acquitted of violating Nichols' civil rights, causing death, but convicted of a lesser charge of violating his civil rights causing bodily injury. He was also convicted of a conspiracy to witness tamper, charge that the others were acquitted of. The court remained silent as the verdicts were read. The judge ordered all three officers to be taken into custody. He planned to hold a hearing Monday to hear from the defense lawyers about releasing them pending sentencing. The witness tampering charges carry possible sentences of up to 20 years in prison. The civil rights charge against Haley carries up to 10 years. They had faced up to life in prison if convicted of the harshest charges. The victory marked a partial setback for prosecutors who were unable to land a conviction for civil rights violations for two officers who played an active role in the encounter. Jurors repeatedly watched graphic clips from police video that showed the officers punching and kicking Nichols and hitting him with a police baton just steps from his home as the 29-year-old called out for his mother. In a statement, Assistant U.S. Attorney General Kristen Clark, who oversees the Justice Department's Civil Rights Division, said Tyre Nichols should be alive today. We hope this prosecution provides some measure of comfort as the law enforcement officers tied to his death have been held accountable. Bean and Smith were seen on video wrestling with Nichols and holding his arms while also hitting him. But the jury was not convinced those actions amounted to civil rights violations. An FBI agent said Smith told him he punched Nichols, but defense lawyers argued Bean and Smith were merely slapping Nichols' hands away as they put handcuffs on him. Rodney Wells, Nichols' stepfather, told the Associated Press outside the courtroom, "A win is a win. They're all going to jail." Five officers, the five officers you see on the left side of your screen, were charged in Nichols' death, but two pleaded guilty and testified against members of their old crime suppression unit. Prosecutors argued that Nichols was beaten for running from a traffic stop, saying it was part of a common police practice referred to in officer slang as a street tax or run tax. They said the officers lied to a superior, to medical professionals attending to Nichols, and in required written reports about the extent of force they used. "This has been a long journey for our family," Rovon Wells, Nichols' mother, told reporters. "I'm actually in shock right now because I still can't believe all the stuff that's going on. But we're happy that all have been convicted and they have been arrested." Smith's lawyer declined to comment. Attorneys for Bean and Haley did not respond for requests for comment. Nichols, who was black, ran from the traffic stop despite being hit with pepper spray and a taser. The five officers who were fired after the beating are also black. Some of the most emotional testimony at the trial came from one of the officers, Desmond Mills, who took a plea deal in which prosecutors called for up to 15 years in prison. He testified in tears that he was sorry that he left Nichols' young son fatherless, and that he wishes he'd stopped the punches. Later, he testified that he went along with the cover-up in hopes that Nichols would survive and the whole thing would blow over. Nichols died on January 10, 2023, 3 days after the beating. His son is now 7 years old. The other officer who reached a deal with prosecutors, Emmett Martin, testified that Nichols was helpless while officers pummeled him, and that afterward the officers understood they weren't going to tell on me and I wasn't going to tell on them. Under his plea agreement, prosecutors will suggest a prison sentence of up to 40 years. Defense attorneys sought to portray Martin as a principal aggressor. Martin testified Nichols was not a threat, yet he acknowledged punching and kicking Nichols in the head. Mills' lawyer declined to comment. Martin's attorney did not immediately respond to a phone message. The police video shows the officers milling about and talking as Nichols struggles with his injuries. An autopsy report shows he died from blows to the head. The report describes brain injuries and cuts and bruises on his head and other areas. With the federal trial complete and other investigations and court actions still aren't settled, the 5 officers have also been charged with second-degree murder in state court, where they pleaded not guilty. Although Mills and Martin are expected to change their pleas, a trial date in state court has not been set. The U.S. Department of Justice is conducting a patterns and practices investigation into how Memphis officers use force and conduct arrests, and whether the department in the majority black city engages in racially discriminatory policing. The Justice Department also has a separate review concerning use of force de-escalation strategies and specialized units within Memphis Police. Pastor Earl Fisher, a Memphis activist who has long called for investigations of the city's police, said he hopes the probes provide us with the remedies we so rightly deserve. Additionally, Nichols' mother filed a $550 million lawsuit against the city and its police chief. Ben Crump and Anthony Romanucci, lawyers for Nichols' family, said the verdicts bring a measure of accountability for his senseless and tragic death. Our fight for justice for Tyree is far from over, the lawyers said in a joint statement. And as I've read that article, I keep thinking, why? Sure, you had him at the point where you can put the cuffs on him. Was it necessary to put these hands and these feet to his head? Was it really necessary? As far as the federal case, justice served, maybe. As far as the state case, we'll just have to wait and see what develops then. And now a Karen Reed update. Karen Reed is seeking to delay her wrongful death suit until after the murder trial. Just when you thought this case couldn't stretch any further, Karen Reed is seeking to delay a wrongful death suit filed by the family of her Boston police officer boyfriend until a criminal trial in connection with his death is done. The lawsuit filed last month blames the death of John O'Keefe on Reed, and also on what it describes as negligence by bars that continued to serve drinks to her despite signs she was drunk. It says the first bar served her 7 alcoholic drinks in about 90 minutes on the night of January 28, 2022, and that Reed carried the last drink into the second bar, where she was served a shot and a mixed alcoholic drink within an hour. Reed's attorneys on Wednesday filed a motion to delay a trial on the lawsuit until after her criminal trial. Reed is accused of ramming into John O'Keefe with her SUV and leaving him for dead in a January 2022 snowstorm. Her 2-month trial ended in July when a judge declared a mistrial, and a second trial is scheduled for January 27th. A stay is appropriate here, where proceeding with this civil action at the same time as the criminal action will adversely affect Ms. Reed's Fifth Amendment rights and ability to vigorously defend herself from criminal prosecution, her lawyers wrote in the motion, adding that her requested stay is minimal and not prejudicial, since the wrongful death lawsuit is not expected to be finished until at least August 2027. But an attorney for O'Keefe's brother, Paul, and other relatives who filed the lawsuit opposed any delays and suggested the reliance on the Fifth Amendment ignored the fact she has spoken publicly about her case several times to the media and will be subject of at least one upcoming documentary. Quote, Ms. Reed consistently and voluntarily disregards her Fifth Amendment privilege as she attempts to craft her own narrative and poison the jury pool for both her criminal and civil cases. That's according to O'Keefe's attorney, Mark Diller. In light of her open willingness to speak publicly, Ms. Reed's current reliance on her Fifth Amendment right to silence appears to be less about avoiding self-incrimination and more about controlling the narrative to suit her interest. End quote. The lawsuit in Plymouth Superior Court in Massachusetts by Paul O'Keefe on behalf of his family and his brother's estate names Reed, the Waterfall Bar and Grill, and C.F. McCarthy's as defendants. It asked for a jury trial. Reed has pleaded not guilty and awaits a January 27th retrial on charges of second-degree murder, manslaughter while operating a motor vehicle under the influence, and leaving the scene of a fatal accident. Her 2-month criminal trial, as I mentioned, ended in July when the judge declared a mistrial after jurors said they were deadlocked. The judge dismissed arguments that jurors later said they had unanimously agreed Reed wasn't guilty on the charges of murder and leaving the scene. After the bar hopping, Reed, a former adjunct professor at Bentley College, dropped off O'Keefe, a 16-year member of the Boston Police, outside the Canton home of another police officer. His body was found in the front yard. An autopsy found O'Keefe died of hypothermia and blunt force trauma. Reed's lawyers argued that O'Keefe was killed inside the home and that those involved chose to frame her because she was a convenient outsider. The lawsuit says Reed and O'Keefe had been arguing and that she knew she had hit him with her SUV before returning to his home. It alleges that she woke up his 14-year-old niece several hours later saying that something bad had happened to O'Keefe and that he might have been hit by her or a snowplow. It doesn't end. It does not end. We'll just have to wait to see what comes next in this particular case. And just when you thought I was done, with this, is now I have another episode of Diddy Do It? This time, it's the family of Tupac Shakur, who was hiring investigators to find a link to Sean Diddy Combs. So, instead of reading the article, I'm going to take you to Court TV's Breaking News with Kelly Craft and Julia Janae as we go over this.
Welcome to Court TV Live. We are following new developments in the case of the hip-hop mogul who is facing RICO charges in New York, Sean P. Diddy Combs. Court TV has just confirmed that the family of Tupac Shakur is investigating a potential link between the murder of Tupac and Sean Diddy Combs. This coming from attorney Alex Spiro, who represents Tupac's family. Now, this investigation had been previously reported by unnamed sources, but earlier today, Spiro confirmed to our Court TV team that he and a team of investigators has been hired.
Sean Combs allegedly had business dealings with Dwayne Keefe D. Davis.
who will go on trial next March for the murder of Tupac. This was back in 1996. Some have speculated that Diddy ordered Tupac's death. That, of course, is just a theory at this point, and we are monitoring the developments in both the Tupac murder trial and the federal indictment of Sean Diddy Combs. So a lot of information to come on that one. In the case that continues to roll on, let's bring in National Trial Attorney Michael Jafer just to talk about this new news of an investigative team that has been hired by Tupac's family. We don't have more details about what they found so far and exactly what avenues they are taking to do that, but what does that say to you? What do you think is happening, and how serious is this when someone hires an investigative team in a murder trial that's being handled by authorities, but this is a private entity requesting this?
Julia, I always say, landslides don't happen slowly, right? You'll be standing on the side of a mountain admiring its beauty and glamour, and then 1 second later, you're buried in mud, right? This does not shock me. This does not surprise me. I can promise you this is not the last thing that we find out about people investigating Diddy and what he's done. This is not the first. We know of an attorney now who represents hundreds of families who are suing him for, alleged, freak-offs and sexual misconduct. So what this tells me is that it's just a piling on. Pretty much people knew for decades what we're going to start finding out things that people have speculated on for decades, and they're just going to pile on, because at the end of the day, how's he going to defend himself at this point? He's got a ton of money, he's got a ton of attorneys, but even if you have unlimited money and unlimited resources, if you are sued, by 100 different people, 100 different times, 100 different theories, at the end of the day, you as a professional defendant operating from a jail cell, you cannot overcome that. You just can't do it. And people know that they can pile on. People who probably wanted to go after this guy just feared going after him because they feared the retribution. They feared that, they walk into an attorney's office, hey, I have this theory against Diddy. And the attorney would tell them, okay, do you have $1 million to pay me for me to waste my time, waste your money and go after him? No, I don't. Can you do it on contingency? No, I won't do it on contingency, because if I do it on contingency, he's going to spend millions of dollars to crush us, right? So that's exactly why these theories have been rebuffed. Right now, people now have, any attorney will jump up and say, yeah, I'll represent you. I'll sue Diddy. I'll be on the headlines. I'll sue Diddy for you tomorrow, right? Yeah, I'll do it on contingency. At the end of the day, that's what's happening. You're going to see many, many more instances of people coming up with theories against Diddy. With respect to this specific one, as a kid growing up, I loved Tupac, and there was, when we were in high school and Tupac died, everybody said, hey, Diddy did it, right? And it was kind of like, back then it was Puff Daddy, right? So a lot of people say that. I don't know if, what the quality of this type of theory is, but hey, I'm going to be interested. I'm going to be glued to the TV to see what happened, the connection between Diddy and Keefe D. Let's see. But at the end of the day, that's what's happening. It's a piling on.
Yeah, I mean, back in July, I think there was a report that Sean Diddy Combs had said, any kind of connection here, this theory is absolutely ridiculous, absolutely false. So we'll have to see what comes of this. But I believe we have some sound we can play, Michael, and then we're going to get your reaction to it on the other side.
So it's Pharrell, you, Puffy, Zip, and a bunch of Southsiders. And what Puffy makes kind of an announcement?
Yeah, that was stupid as hell too,
What did you actually hear? What was the words? The best you can remember what he says.
He said he'd give us anything for them dudes there,
Give us 5 names of people who would say, yeah, we heard Puffy say that.
You don't have to come from, they don't. Al, Corey, Wynn, Dirt Rock, all of them would tell you.
Now, this was before the arrest of Diddy, Michael, but what do you take from that? I mean, it's just everything, as you just mentioned, it just keeps piling on.
Yeah, this specific one, I'm very familiar with this exact case with this person. What you heard here was not credible, right? Even if it's true, it's just not credible. It's too old, it's too stale, it's not credible. What happens in that life is people will talk and talk, and this Keefe D has proven himself to be the type of person who wants attention and talks a lot. And how do you get attention? The way you bring attention, if you're this type of a person, is you bring up the names of people who are much bigger than you. They say you punch up, you don't punch down. He's not going to get attention if he says, hey, my friend here, my neighbor was the person who was behind, him, and these are the 5 people that helped me kill Diddy. No, to kill Tupac. No, he'll say Diddy did it, all these other people. So at the end of the day, it's just not credible. I don't think this is going to go anywhere. People have hunted down the cause of the death of Tupac, and now they've focused on this Keefe D guy, but I don't think other people are going to be brought into it. I just think it's bunk.
All right, Mike. Well, thank you so much.
And thanks to Michael Jafar for his expert commentary on this crazy saga. This saga is indeed crazy, and I'll be honest. Back in the day when I first really got into hip hop, when Tupac was shot, yeah, I was one of the first people on the East Coast to say, yeah, Puffy did it. But right now, I would be in a state of shock if he actually did do it. If he actually had a hand in that. Until then, we'll tune in next time for another edition of Did He Do It? I've got one last story before I go to last rites. And that's the case of Ewan DeWitt, excuse me. He is accused of killing Julie Minogue, the mother of his children, with an axe while his kids were at home. And now, he is being offered a plea agreement. Yeah. A Connecticut man is accused of killing his ex-girlfriend in front of their 3-year-old child was in court on Friday, where he was offered a plea deal to resolve the case. Ewan DeWitt is facing multiple charges, including murder, in the December 2022 death of Julie Minogue. At Friday's hearing, prosecutors said they had extended a plea agreement to DeWitt that would require him to plead guilty to murder for a sentence of 45 years. Prosecutors noted that the victim's family was not in total agreement with that offer, saying they wanted him to serve more time. Authorities say DeWitt, age 44, killed Minogue, 42, with an axe in front of their child. Minogue's 17-year-old child told police he saw DeWitt standing over his mother's body. Days before the killing, Minogue was granted a no-contact restraining order against DeWitt. She had also had a protective order against DeWitt following a 2019 incident where he was arrested for assault. DeWitt's attorney said he plans to meet with his client at the jail next week to discuss the plea offer. The parties will return to court on October 25th, where DeWitt is expected to formally accept or reject the agreement. Now, let me look at this man's age again. The plea agreement is for 45 years. He's 44. God forbid he makes it, he will be, let me see if I got this right, 45. He would be 89 by the time he got out. 89 years of age. And the family still wants him to spend more time. Well, if you think about it, 45 years could very well be the rest of his natural life. But for a murder as gruesome as this, I'm kind of on the fence. Should he take the plea deal? Should he not? I don't know, guys. You let me know what you think. All right. So now we have come to the end here, and now it is time for me to read last rites to 3 convicted murderers. Pamela Bordeaux, convicted of shooting her former son-in-law, and Karen and Michael Murray for killing and neglecting their very own mother. Whew. When the Reaper calls your names, there is no apology. When the Reaper calls your names, there is no remorse. When the Reaper calls your names, it's just over. Bordeaux, Murray siblings, the hounds of hell are baying for your respective souls. And the gates of hell are opening and welcoming you three to your eternal damnation. Pamela Bordeaux, Karen Murray, Michael Murray, your names have been called. And when the weight of your guilt consumes you, you three will never rest in peace. That's all I got for this week's edition of Bethea'S Byte Reloaded. I want to thank you all so much for joining me here. And if you got anything to say about the new display, let me know about that too, because I'd love to hear from you. If you all want to get in contact with me, I'd love to hear from you. You can follow me and Bethea'S Byte Reloaded on Facebook at Bethea'S Byte Reloaded, on X at EKB316, that's in all caps. Here on YouTube at Bethea'S Byte Reloaded. On Instagram at EKB316, that's in lowercase. On TikTok at King of Hearts 316 2021. Or you can email me. The address is kingofhearts316_09 at outlook.com. Remember where you were. This is the home for true crime news without all the drama. This is where your opinions matter, where lively debates are encouraged, where your voice is heard, and above all else, it's justice served. Ladies and gentlemen, this has been and will always be Bethea'S Byte. And it's reloaded. Thank you all so much for joining me. I'm Ernest Bethea, the Last Outlaw. I will see you next time. And until then, you all know what to do. Bye. Thanks for watching and joining me here at the drama-free true crime destination. Be sure to like, share, subscribe to the channel, and drop me a comment on this video. Also, be sure to follow Bethea'S Byte Reloaded all over social media. This is Bethea'S Byte, and it's reloaded.